2-3 days don't burden us. We'll have to rise early. What is this matter about? That we can take it up, don't worry. But long matters, kindly excuse us. Yes. That will reach otherwise also. Yes.
Okay.
Code number 4. Not here. Code number code number 4.
One, my lord, I'll start my day with a seeking apology. Last date we are directed to bring on record.
Yes.
My lord, we couldn't do it. But however, my speaking order has been passed.
You have
My
passed.
lord,
Have you
yes,
considered
yes,
speaking
yes.
order has been passed?
Yes, my lord. This,
Given a copy to the other side?
this I can give now, my lord. It was passed yesterday, and there was a messenger coming from Nagaon with this copy. Here, my lord. Invoking, my lord, the Wildlife Provision Wildlife Act, the request of the petitioners to harvest, my lord, and access in wildlife has been denied, my lord. And copy has been marked to them, my lord, the secretary and also the notice board.
It was passed yesterday.
Yesterday.
Probably physical copy they are yet to receive, probably.
My lord,
Just now I have received.
my lord,
No, even your clients.
Yes, ma'am.
a messenger is on the way, my lord. He is bringing the original copy.
No, it's okay. It's okay. It's okay. But we need. He needs to get. He needs to respond to this.
Yes, that
He
is-
can put this to challenge. That's a different matter. Otherwise, also your at least instructions from your client. They have cited certain reasons whether these are germane, relevant or not.
I don't know, my lord, because my lord, till my lord, the last notification, the 14/2, everything was, my lord, in smooth manner. There is nothing, my lord, any afraid of any tiger and anything, not even spotting the area, my lord. Now, because of this spotting of the tiger, but interestingly, my lord, while they have evicted us, they still allowing, my lord, the certain, my lord, this called Goru Kuti. Is the people, my lord, rearing the cow and buffalo inside the, my lord, wildlife protection, my lord, the area.
that is a
still there,
different
my lord.
aspect. Gorukuti was
That is still
acquired
there,
for
my lord.
different purpose. my
No,
lord.
my lord, this is the photographs I have obtained and fishing also there. This is the photographs, my lord, they are allowing them. And I have specifically mentioned in my petition also that they are still allowing. The number of photo, my lord, Goru Kutis and Mohor Kutis are there, my lord. They are rearing with the cows. and
Mr. Gogoi, we ideally wanted this to be on record by way of an affidavit.
My lord, I will
But,
bring on
uh,
record. Yes.
Plus, but we may not insist upon that since you have placed on record by this order giving to the copy to the other side. We may seek their response.
Let them. Let them.
My lord, my one.
If you want to file an affidavit, we can still grant you a short time. But I think this is a self-explanatory
My lord.
speaking order. They can respond to this.
My lord, one aspect, my lord, they, whatever, my lord, I have paid for it only for the harvesting, nothing else.
That has been denied.
That is denied. This ground, sir, my lord, is a very flimsy ground. I did not. my
That
lord,
is it.
flimsy. And so far, my lord, the period of harvesting is, my lord, it is almost over, my lord. So after the remaining, nothing will remain, my lord. Nothing will, and even the order will pass by your lordship, my lord, I will never get anything from this, my lord. Because the high time of harvesting is already gone. And the remaining hardly, my
But
lord,
without adjudicating the validity of the reasons cited, passing order either in favor of the
lordship have a ample power to interfere, my lord, because
no,
my
no,
lord, the
but see, they have cited certain reasons.
reasons are
Without
there.
hearing, can we say that the reasons are not?
These reasons are there, my lord. Why the Goru Kutis and other, my lord,
This will
now
require
they are allowed to inside, my lord.
That is exactly what we are trying to hint upon, that this will require some hearing. And without your response, tomorrow they might say you have not even.
My lord, I paid, my lord, whatever maybe, my lord, I will respond these things, my lord, within, today. is
By
the-
Friday,
Friday, I will, my lord, before that, I will file, my lord, this affidavit and this.
you file your an affidavit to this speaking order. We'll record that
Yes,
copy has
I
been
will
given to you.
And my
And
lord,
Monday next we can take it
and
up.
my lord, the Friday, my lord, the matter maybe, my lord, regarding the.
Monday.
Friday is a Good Friday, my lord, holiday. 7th.
Monday.
The Monday, my lord, this matter will be decided regarding the entry, my lord. Otherwise, my lord, this nothing will left, my lord. And the other, my lord, the party notice may be issued on that other issue, my lord, because the other issues are involved. I prayed for the other things also.
We issue notice in the,
Otherwise, my lord, because notice also not issued on the other issues, my lord, because I'm paying for the compensation and other relief
And
also.
that issue, my lord, was
has
regarding
been
the
responded by the
eviction has
affidavit,
been
my lord.
and regarding compensation, my lord, forest department need not be implemented, my lord, because
That
no-
will be later, on, that will be decided. And right now,
issuing
they cannot say.
notice is not a big problem. We are only soliciting your response.
well, no, we have already filed an affidavit, my lord, opposition.
Okay, we can
Fine, my lord.
issue notice. Affidavit filed in which one?
Not in this, my lord, earlier one.
722, my lord.
722.
722.
And the other one, 13.
It's not this one.
1537, my lord, this prayer was, my lord, this has been. My lord, they're seeking compensation internally also, my lord. One limb of the prayer goes,
Okay,
Another
we'll record something and issue notice.
my lord.
Will you file affidavit in this or what?
On this, my lord.
Yes.
Yes, I have to respond, my lord.
Then Monday should we fix it?
Yes, my lord. Friday, I will file one amendment.
Then where is the requirement of issuing notice? We can have it for motion also.
Yes, my lord.
Because if you issue notice, we have to give some time. The question of service will also come.
After this one, deciding that it lot of
Okay,
time.
in terms of the earlier orders passed by this court, including orders dated 3/3/2023 and 31/3/2023, comma, 3. D. Gogoi, learned Standing Council, Forest Department, has informed that on 3/4/2023, a speaking order has been passed by the DFO, Nagaon Wildlife Division, whereby the prayer of the petitioner to allow them to harvest the crops has been rejected. Full stop. A copy of the said speaking order has been placed on record and another copy has also been furnished to Sri P. Mahanta, Learned Counsel for the petitioners. Full stop. Para. Sri Mahanta, the Learned Counsel for the petitioners, submits that he would like to file an affidavit with regard to the speaking order. Full stop. Let such affidavit be filed within by Monday next, on which date this matter may be listed for motion along with WPC 1537/2023.
Always.
Not so much.
Item number 4, Lordship, my affidavit has gone for vetting today, Lordship. I have received my paravoice last evening, Lordship.
What is
In
the
item
stage?
number 3, my lord, we have filed an affidavit in reply today and my learned friend has received the copy. And in item number 4, as she has told me that she is.
The
going-
counter affidavit has gone for vetting.
Yes,
my lord.
Lordship.
What is the stage? It
So,
stopped
my
or what?
lord, as on date, they have basically kept the tender process under, my lord, after passing of this.
In
order-
advance.
In advance, my lord.
Okay, okay. How soon can you file the affidavit, madam?
Lordship, today it has gone for vetting, Lordship. I'll file it by today itself. And in the additional affidavit, Lordship, I want to give my objection, Lordship. There are certain allegations that he has alleged, Lordship.
A certain, my lord, documents we have brought in because the statements we have.
We'll
made-
consider, but not
Yes,
at this stage. When do you
Madam-
fix this matter?
My lord, any dates subject to my offense convenience, my lord?
Which date? Tell us a date.
Lordship, after vacation, Lordship, it will be convenient because Mr. D. Sakia will be appearing in this matter.
You had expressed urgency. I'm leaving
That's
it to you.
Lordship.
It's your,
Then all the pleadings will be complete, Lordship, after the vacation.
if it serves your purpose, if it's to your convenience,
No,
then you'll
in
take
the
a long
month of
date.
April
If
of
it's
Lordship,
not
Lordship,
convenient, then you'll take a short date.
No,
But
Lordship,
it was
because
very urgent for you.
April is the sowing season, Lordship. So, Lordship, the pleadings will be complete by then, Lordship. Or else on the tenth, Lordship, again, he'll not be available, Lordship, Mr.
Okay, but next time don't talk about urgency then. Last time you were not even giving 1 day's time to file affidavit. You have to maintain a standard. Convenience, inconvenience can be of both the parties. And we are here not to give unnecessary time. We are
Last,
also,
Lordship,
we are also conscious about the matters.
they have given me an incomplete paravise comment, Lordship. So again, I have to send.
The
it back
department
and-
is not very keen in defending. Okay, it appears that the pleadings are yet to be finally exchanged. Full stop. As read by M.S.R. Bora, Leonard, Standing Council, Agriculture Department, list for motion on
21st.
May I make a prayer, my lord?
on
21st, Lordship, 21st April, Friday.
21st April. Yes, anything?
My lord, may the matter be posted for admission because by that time, my lord, anyway, the pleadings will be completed, my.
Can it be there? It doesn't matter. On 21st,
First, Lordship.
full stop. By which time all the pleadings are required to be exchanged.
My lord.
Full stop, para. Interim order passed earlier to be continued. Stands extended till the next date of listing.
I'm deeply obliged,
Obliged.
my lord, deeply obliged.
My lord, in this case,
Yes,
the adjudication order was passed, my lord, only on the basis of the 26A statement of the income tax. Now, the issue is that, my lord, whether the service tax can be imposed on the.
on
basis
the
of
last occasion, of course, you were not there, Mr.
My lord,
Sharad.
I'm coming
He
to
had
that.
raised an objection
No, no,
regarding.
I'm coming to that, my lord.
That is, all the matter has been fixed on 20th of April.
No, just let me. Complete. Well, first, my two reasons are there. First of all, similar matters on this issue are pending before this honorable court. And one of the matter has finally been decided by remanding the matter back to the authority on the same ground
By this court,
by this court.
irrespective of there being a provision for appeal.
Yes. Now, one matter is already pending. And secondly, my lord, my learned friend is again and again showing the division bench judgment that. But in fact, you also have seen the judgment of the apex court. My lord, no automatic, the appeal is there. So the, my lord, on the ground of alternative medical dismissed. If you also wants to look into it, I can show the judgment, not 1 or 2 lines. Dipankar.
No, the division bench has taken into consideration the latest judgment of the Supreme Court.
So I am also, this is the February 2023.
Yes, what is the name?
This is my lord, Godrej Sarali.
You
also see the Godrej Sarali, what it says.
not this one. What was your judgment?
That is, should I have not.
Very early judgment.
The Honorable Division Bench has referred that.
November 2022.
And what was the name?
What's it?
People should be in mention. It will be. Yes. This is the latest judgment.
That is lordship.
Commercial something.
Commercial still.
Yes, commercial stills, yes. Commercial
Thereafter
stills.
in February, another judgment is in passed. There was placed by a learned friend, that case which I.
This is February 1.
This is 21,
23.
23. Yes, 1st February 23.
This is 1st of February 23, and that one, commercial stills?
Commercial, it is to 2021. SC, on.
No,
online.
date of the judgment,
Probably it is in the month of November, Lord.
22,
Yes, Lord.
22, this
21.
21,
It was reported in 22. So it has to be, my lord.
either before 22 or 20. You know, but this is what the latest.
That is,
Here you also will find
Are you aware of this, Godrej
Lordship,
Sarali?
Yes, Lordship. So in this case, two things have been held, my lord. That if only issue is of the question of law, then the petition should not be dismissed. And secondly, there cannot be any automatic dismissal on the ground of, my lord, the alternate remedy. Each fact has to be examined, whether the conditions have been fulfilled or not. You also will see para 4,
Mr. Dr. Saraf, see paragraph 7.
my lord. Para 7. Yes, my lord. In the middle, you also may see, my lord.
No. This has taken into consideration the judgment.
One full.
No, paragraph 7.
Para 7, I am reading, my lord.
Not too long ago.
My lord. Not too long, the court is decision reported in so and so. Assistant Commissioner of Commerce, that is citing, my lord.
That is, it has been taken into consideration, Mr.
It has been taken into consideration thereafter, my lord, the judgment has been delivered.
So I think,
Lordship, since Lordship has fixed all the matter on 28th.
In my case, there is no question of, my lord, that issue. In fact, my lord,
when was what is the judgment of the division bench that remanding matter?
is simply
That
said, my
was
lord,
dismissed.
No,
Because statutory
It is
review-
the-
Since the appeal is there on the ground of availability of
Yes.
seat,
that
what was the date?
Lord, this is I am giving you.
23rd of February.
So much pressure on it.
Last time you had placed this,
18-4, Lordship.
huh?
Yes,
No, this is not.
No.
it is also being in
The recent judgment,
Yes, Lord. It is the one.
TV judgment,
It was,
referred commercial stills. What is the date kindly?
the date of judgment,
Maybe March.
Huh?
20th February 2023.
But This
30th of February.
this was not placed.
No,
Yes,
Godrej Sarali was not placed.
That was not placed.
Mr. Kyal was there, he had not placed me.
No, Lordship.
He was not aware of this.
The counsel for
That's what
the,
one of you will give it to him.
Well, the reason is that, my lord, that you lost your aware. Otherwise, the earlier principle, the violation of principle naturalistic jurisdictional error. And in one of the judgment from Tripura, it says that will a high-handed order. If the high-handed order there, then also alternate remedy is not a bar. Now, my lord, the earlier it was only arbitrary without jurisdiction, violation of the, my lord, the fundamental rights. But what more was added, high-handed order. Because, my lord, alternate remedy, it has become, my lord, ultimately, when a lordship is jamming in 226, then there is no bar.
But one matter where Mr. Shah is appearing, R. Shah,
that is the,
I think we have fixed only for that purpose.
that is the
Or
Lordship.
addressing this court on the point of alternative remedy. What about Satyavati Tandon, the matter of DRT? Many things has been said.
Yes, Lordship.
Whirlpool has been explained again.
And in one, that State Bank of India, that is also there, Lordship.
Here, Whirlpool has been followed and the commercial has been explained. And thereafter, my lord, it says,
Let us have it on 28th.
my lord, I have no problem, my lord, I can also address your lordship on
yes,
the. That one. In the meantime, my lord, your lordship may issue notice in this case because the similar, my lord, the petition has been decided finally. I can give the judgment in that. On 26 years, it has been said that no assessment cannot be made on the basis of 26 years.
No, we may issue notice. We leave the maintainability point open to
Yes,
be heard on the maintainability issue. And 28th, I think it will be
And the
good.
coercive measures may not be taken. my lord.
Yes. Don't take
Earlier also,
coercive measures.
similar matters. Earlier, also same order has been
And
passed.
we'll take your matter along with those.
So that I can also address
Yes,
your
we
lordship.
can have your assistance also. But there are matters on the DRT side.
So that are,
Yeah,
it has to be different. That DRT is altogether
The
different.
objection has been sustained. That alternative remedy is, yes.
There are many judgments. Lord.
So many judgments are there, starting from Titagarh and all this. Titagarh also has been discussed. here.
Titagarh has been
Discussed here.
discussed here.
Now, DRT is a different concept also, banking, my lord, I will show to you, lordship, my lord, the way it has been passed. Different things are on the
Yeah,
different. concept.
you can distinguish, but that's also a statutory appeal. This is also a statutory
No,
appeal.
no, my lord, state appeal, normally the court will try to see that you should avail of it. But the conditions which are the exceptions which are there, the court has to examine whether those conditions, anybody is raising those issues or not.
But we cannot open a floodgate for writ, for a writ court.
But my
What will
lord,
the
lordship can-
tribunal, what will the
lordship
appellate?
cannot delegate us to the high-handed order also. The lordship
No,
also
that-
see.
It will be on case to case basis.
Otherwise, he will be very happy with that.
But
because-
one thing you have to satisfy that what is the prejudice you are going to suffer or apprehend that justice will not be done by the appellate
No, my lord,
authority.
that is not required. If the order is without jurisdiction, if the order is arbitrary, and if the order is below.
No, that is okay,
Then, my
but
lord, the
but
preceding
will
question,
will it preclude you from approaching the appellate
my lord,
authority?
that may be there.
Jurisdictional point can't you raise before the appellate
Can be
authority?
raised.
You can.
My lord, but the, my lord, no,
And
says,
perhaps that would be a more efficacious
my lord,
remedy.
the applicant says the delegated, it is delegated to the authorities. Not only the pre-deposit, but the person concerned. My lord, that gets it that, no, immediately the 226 is that to take care of the orders which are prima facie, my lord, absolutely without jurisdiction. Then your lordship will interfere. Otherwise, my lord, they will pass orders that yes, go to the appellate authority. And who are sitting in the appellate authority? Departmental officers.
That is the statute. We have not challenged.
Well, I
You have to
understand.
challenge that this kind of appeal is not
Certain
in accordance with law.
other things will come, naturally, my lord, we will
No,
also come up-
these are matters of deliberation. We'll
my lord,
discuss.
because the,
I'm just,
no, yes, your lordship, absolutely, my lord, he has
we have to
given
expect
us-
from you.
it has also given us, my lord, some materials to examine again, my lord, on the basis.
Heard Dr. Saraf, A. Saraf, London Senior Counsel, assisted by Sri P. Borwa. Full stop. The present challenge, please have your seat,
My lord.
is with regard to an order dated 23/5/2022 passed by the additional commissioner, goods and service tax, Aizawl, whereby the demand of service tax amounting to rupees 1,17,27,034 for the financial year 2014-15 to 2017-18 has been confirmed. Full stop. The same has been done in terms of section 73 within bracket 1 and 68 of the Finance Act, 1994, and Rule 6 of the Service Tax Rules, 1994, read with section 174 within bracket 2 of the CGST Act 2017, full stop. Along with the state order, a penalty has also been imposed amounting to rupees 1,17,27,034 under section 78, apart from another penalty of rupees 10,000 under section 20 of the Act. Full stop. Various grounds have been cited in support of the challenge. Full stop. On the other hand, Sri S.C. Kyle, the Learned Standing Council, indirect taxes? What do you call yourself? The Senior Standing Council?
Central Board of Indirect Taxes.
Central Board of Indirect Taxes. Issues a preliminary objection, raises a preliminary objection on the maintainability of this writ petition on the ground that an alternative remedy in the form of an appeal is available. He further submits that similar matters are related to be listed on 24/2023 on the issue of maintainability. Full stop para. Be that as it may, let notice be issued, returnable on 24. Sri Kyle, the Learned Standing Council, accept notice on behalf of as per numbers 2,
All the
3. I think 1 Union of India Finance Ministry, somebody else will take. Anyone? Sri R.K.D. Chaudhary, Learned Deputy SGI, accept notice on behalf of respondent number 1. Sri R.K.D. Chaudhary, Sri S.C. Kyle, Standing Council, so and so, accept notice on behalf of respondent number 2,
2 to 6.
Tier 2, 6, 2, Tier 2, 6. That extra copies of the writ petition be served upon the Learned Council for the respondents. List this matter on 24/2023 along with WPC
I've given the order, Lord.
along with WPC 4614/2022. Or 2022, full stop, para. Heard the Learned Council on the interim prayer, full stop. Till the returnable date, comma, it is directed that no coercive action be taken against the petition.
Achha.
I'm obliged.
In terms of the scheme, Lord, we have made the payment, my lord. Second option we have opted for.
Anything, madam?
31st March.
Did not receive any instruction.
Sri R. Dubey Learned Council for the petitioners submits that the second installment has been paid in the meantime, full stop.
That the entire payment has been made in terms of the second option of that.
Oh,
scheme.
sorry. That the payment has been made in accordance with the second option made available to the petitioner, full stop. Miss, your name?
Yes, they,
As the Learned Council for the IDBI.
I did.
IDBI, however, submits that she is not equipped with instructions today, full stop, para. List immediately after the BU vacations to enable her to obtain the instruction. The interim order is required to be
Review of
extended.
Entire payment, right, let it be continued. Lord.
Interim order passed earlier, that's extended till the next date of listing.
Deeply.
As the Purva,
On this matter, the Home and Political Department sought some time to obtain instructions.
I think you're mistaken, it should be this side, aren't you?
No, my
For a change, you're on this side.
my lord, yeah.
Should come to this side. I think it's time to change side.
I'm too young for that, my lord.
Nobody is too young. Yes,
In fact, instruction has come in. So from the going through the inspection, I could make out that they have denied that there was any prior approval from the government as regard the appointment. So This appointment has been done post-dated. And there is no such provision whereby post-dated appointment can be done, whereby a person is entrusted to represent the government. And thereafter, the order is being issued. So here also the learned LR has come up with his report, and this two sets from the report and the content of the report, I could make out that first thing is that all the amount that has the state coordinator has given is taken as a on the personal capacity that appointment has been done. So the government has tied away from the responsibility, and this
We have to
amount
put
needs
this
to
on
be
in-
recovered.
you have to put this on affidavit.
Yes, sir.
Number one, number two. Ultimately, the job has been done.
Yes.
Now,
Now,
whom
now say,
whom do we settle? Somebody has to pay. We are not on the rate.
yes,
That's a different aspect altogether, whether it's a reasonable rate, but somebody has performed certain duties,
yes, yes, yes.
maybe on assurance or
But
something.
at the same time, now they have challenged as
How do you
regard the
reconcile?
appointment.
How do you reconcile?
They have
It's your
disputed the
appointment.
appointment.
Can you recover the amount from the officer? Have you taken such a stand?
In fact, I'm not, from this instruction sheet on the last part, it is not clear from whom it is to be recovered.
No, Mr. Barua, it's
yes.
very easy to shrug away from your responsibility, saying that it was not done in order, but ultimately we have to see whether the work was done or not. If it was done-
It is said that it should be recovered from him. So here, him means the erstwhile state coordinator.
You take some action,
Yes,
put it on record,
yes,
but that is one chapter.
yeah.
But what about the remuneration? Again, we are reiterating that we are not on rate. We may not agree upon the amount. But a reasonable rate one is entitled to. If you are discharging your duties like GA today, tomorrow if payment has to be made, we are not going to look into the legality or illegality of your appointment since you are there. At this time, nobody is raising any objection. And it was not for 1 day or 2 days, it was for
2
continuous stint of 2 years, I think.
Yes.
So you have to balance it out after all. You can settle it
Ultimately,
out.
that rate will be guided by the appointment letter because there they might have specified what rate are to be given.
No, there is,
So
there is,
now
there has
later
to be
on-
some standard rates also.
Yes, there is standard rate. The government rates are there. So if at all, who is going to
You
decide?
put this on affidavit.
Yes, I will put.
Harshri, you record his name?
Yes, sir.
Harshri A. Barua, learned counsel for the petitioner. Full stop. Shri S. Barua, learned state counsel has submitted that instructions have been received as per which an issue has been raised regarding the mode of the appointment also, full stop. All these facts are required to be put on record by way of an affidavit, for which this court grants how much time? How much time?
4 weeks.
My lord, a
Not
short
for
date may be
20 meters,
granted, ma'am.
20
We already have
meters.
Short date
instructions.
means in between we have the holidays, so that's why I
Yes,
have.
very good, my lord, after the busy vacations, a
Yes.
short date.
We'll have a date, we'll give you time. Today is 4th.
Maybe on the first week of May,
We'll have it on 28th of April,
My lord.
2/8,
Friday.
Friday.
Yes, ma'am. Oblige me.
Next, Vijay Latif. This matter has been sent for mediation.
Yes.
Takes preliminary report.
Yes, anything has come?
My lord, the mediator visited the sport and apprised himself of the circumstances.
Mediator had gone there.
Perhaps he has, yes, on last Friday, he visited. I apprised him about the
But there was a,
preliminary report he has to submit.
yes. But is it progressing? He had gone
Yes,
there,
progressing.
something.
Yes.
So today was fixed for consideration of the preliminary report to be submitted by the mediator who was appointed by the last order dated 14/3/2023, it appears the record does not contain any such report, full stop. The learned counsel for the parties, however, submits that there is some progress. And in fact, there was also a physical visit to the spot by the mediator, full stop. Sarah, list on 19th,
Continue.
19th,
This
No.
month, 19.
19th. Only for the initial report. For the report, for submission of the preliminary report by the mediator.
That blacklisting matter.
That is not over as yet.
In this case, now both the parties argued this matter.
I think so.
Only thing that your lordship desire to know something, Lord. There is 3 points. I have noted down, what is the meaning of hard hearing? Hard. And
yes.
whether the opportunity of hearing is defined from the opportunity of personal hearing. And whether the procedure of a departmental proceeding will be applicable in that aspect, your lordship.
Yes.
Is a remember this. Lord, I have picked up some cases, my lord. This is a well-known cases known to all, my lord. Reed versus Welding. And this case was referred by the Supreme Court in several cases. Those cases are, should I give the list of those cases where it was referred?
Yes.
Now, Lord, I have originated this judgment, Lord. Here, Lord, what happened?
Yes.
No, Lord, here the ratio, basic ratio is that when an authority is called upon to decide something, then it must be decided by affording an opportunity of being heard. That is one thing that has been decided. And another thing is that if there is a statute and that statute does not contemplate any proceeding for natural justice, then also, my lord, these principles of natural justice has to be complied with. Applying these principles, my lord, this Maneka Gandhi's case where the passport compounding case, which does not comply, which does not contain any provisions for giving opportunity of being heard, that was the Mohan Singh's
The
case.
American concept of due process of law was
Yes,
almost
yes,
adopted.
yes, due process of
Due process of law.
procedure established by law has been converted to due process.
Due process of law.
That is the basic thing, Lord. Yeah, earlier, Lord, it was procedure established by law. Now, by virtue of this reliance of this case, it has been converted to a due process of law. Now, Lord, I will not trouble your lordship. We just refer some paragraph, my lord.
Please.
Then your lordship come to page 1. Now, here the facts of this case, my lord. Facts of this case is that, could I read or I will?
Let us read.
Hmm?
No, not all, everything, only the basic facts.
Could I read or read?
Yes, please read.
Well, the appellant, Mr. Reed.
No, those you can skip.
No, he was implicated in a criminal case and he was acquitted. But one of the trial judges made some remark against him. And because of that remark, in that case itself, a corruption case was initiated, but the prosecution did not adduce any evidence and thereby he was acquitted. On the next day itself, my lord,
He was dismissed.
he was dismissed. No, he was dismissed by virtue of the statute that is under the Act of 1882, which empowers the municipal corporation to dismiss any employee without any employee. But subsequently, but there is a provision in the Police Act of 1919. There is a provision that whenever a disciplinary proceeding has to be complied with, you have to follow the principles of natural justice, the procedure. Now, it was contended, as it is specifically empowered by the statute, we need not follow these things. That was the precise case.
That was the defense.
Huh?
That was the defense.
That was the difference.
No requirement to follow the principles of natural justice.
Natural justice, because
Statute does
we have
not
been
say.
empowered by the statute itself. And our statute, that is why we have exercised it. Now, your lordship may come to page 1.
That provision was there in the Police Act of 1919 or in the 1882 Act?
1882. No, that provision is 1914.
1919.
Yes, 1919, section 4.1.
4.1.
And they are exercised their power under Watch Committee Act of 1882.
Correct.
1882. Now, just second paragraph, the appellant's case is that the proceeding under 1882 of the ward committees were bound to observe what are commonly called as principles of natural justice. Before attempting to reach any decision, they were bound to inform him of the grounds on which they proposed to act and give him a fair opportunity of being heard in his own defense. Now, therefore, all these things are discussed audio, but these things are not very relevant to what your lordship is concerned. It is known to all. So I am skipping it off. Now, your lordship straightway come to page 11.
Yes,
Here, all these principles of natural justice, all these things were discussed, several cases were referred.
Hmm.
Now you all should come to page 11. Now here this concept of void and voidable was introduced. So what will be the consequence of a judgment which is not accomplished by the principles of nature, whether it is a void or it will be a voidable injustice, voidable. Now your Milord come just paragraph 1, 2, I have sidelined it, I have
Yes, yes.
underlined.
next comes that paragraph.
Huh?
Is it-
Next comes.
Yes,
Yes, that paragraph, I have underlined it. Next comes the question, whether respondents' failure to follow the rules of natural justice on 7th March. Judgment was delivered on 6th March, and he was dismissed on the 7th March. On 7th March was made good by meaning on the
We-
7th.
we have read,
Huh?
we have read this. Because 18th March, they realized that he needs to be given up an opportunity.
Hmm.
And so another hearing was done on 18th, so the later decision will be valid.
Hmm.
That is the fine.
That is the fact.
Yes.
Now your lordship come to here at the bottom portion,
Hmm.
the page 11.
Yes.
The other ground on which some of your lordships prefer to proceed is the respondent's failure to act in accordance with the police regulation. Police regulation. I have had an opportunity of reading the speech about to be delivered by my noble and learned friend, Lord Maurice of Portuguese, and I agree with the view about this. I will only add, but here it is important. I will only add that the circumstances in which the Act of 1919 Act was passed and the consequent regulations were made show that
Regulations must be.
regulation must have been intended to have a very wide application. That's the principles of natural justice. And I see nothing unreasonable in applying them in this case, though there is a provision by the statute. In this case, dismissing the chief constable who has not been convicted of any criminal offense is not a thing to be done lightly. If the whole of the matters against him are disclosed to him and he refused to admit some or all of them, it seems to me perfectly proper that there should be some inquiry as to the regulations, as regulations require. In particular, to exclude the case from the ambit of the regulation, because the watch committee did not proceed to any report or allegation, is a very narrow interpretation of the regulations, and it could lead to a strange result. Counsel for the respondent was constrained to admit he could not reasonably have done otherwise, that if some busybody had formally reported to the watch committee the observations of downtown, etc. So let us keep it up. Then there was a considerable argument whether the result of reach watch committee decision is void or merely voidable. The time and again, in the case I have cited, it has been stated that a decision given without regard to the principles of natural justice is void. And that was expressly decided in such and such, such and such and such. I see no reason or to doubt these authorities. The body, that is the main ratio.
Yes, yes.
That is the main ratio. The body with the power to decide cannot lawfully proceed to make a decision until it has afforded to the person affected the proper opportunity to state this case. This is a very simple word, but it has a very, very great consequences. And these two lines principles have converted our system of judiciary. Procedure established by law has been converted by the due process
Due
of-
process of law.
by virtue of these two lines. Now, my lord, your lordship come, this is very, initially I did not understand this. But reading and reading, I don't claim that I have understood everything. But what I have understood, my lord. Now, Lord, your lordship come to page 13. Okay. The 13 last paragraph, accordingly, paragraph 1, 2, 3. Accordingly, in my judgment, this appeal must be allowed. There appears to have been no discussions in the court below as to the remedies which may now be open to the appellant. And I do not think that the House should do more than declare that the dismissal of the appellant is null and void and remit the case to the Queen Bench for further procedure. But in this case, this gentleman has already attained the age of superannuation, so he did not want to be reinstated. And for that reason, then observation was made. But it is a right to put on record that the appellant does not seek to be reinstated as a chief constable. His whole concern is to avoid the serious financial consequences involved in dismissing against the required to allot reason. Next judgment, your lordship, come to page 17. First, second, third line. Upon the second question, whether the decision afterwards impugned can be said to be void or voidable only. This dealt with the case provided, as I think, no certain answer, nor have I found one in textbooks. Indeed, the vast majority of circumstances, it does not the end of the matter, whether the decision challenge is void or only voidable. Or if the court does not decide to quash a decision or otherwise set aside, then the effect in general, the same whether such decision be considered as void or voidable. For my part, however, I have come to the conclusion that a case where a body is acting within the jurisdiction, but of which the courts to say that it has failed to do substantial justice in accordance with the principles of natural justice, then the decision is voidable and cannot be properly described as a nullity. So what they wanted, so yes, if some decision was arrived without compliance of the natural justice, it should not be considered as a void. It can be again rectified by affording another opportunity of being. Probably they wanted to.
But ultimately, what is the finding? Void or voidable?
The voidable.
First, the categorical finding here, that if you are not following the principles of natural justice,
Void, okay, then your lordship come.
these are
So far, we are
Sep-
concerned, we are considering it as a
Separate-
avoidable.
These are separate opinions by different members.
Another judge. Lord. Sir. First judge was, third judge was.
Is there, is there any conclusion by the majority?
Then let us come to page 31.
Notice. No, these only contains the various opinions expressed by the
Judges.
learned judges.
Hmm.
Some,
Now, look, let should come to page
and all
31.
their-
Let-
and
same
all
as-
their opinions are not unanimous.
Huh?
Their opinions are not unanimous. There are variations.
No. So some will say void and some says voidable. But one thing is that the decision must be complied with the principles of nature. When a body is entrusted to decide something, it must be complied. with the
No, the specific question was that will issuance of notice will comply with the requirement of law. Mere issuance of notice, no further hearing given to you. They elicit your response to some allegation. Why you should not be blacklisted? You submit your response. Are they entitled to take a decision immediately without giving you an opportunity? Unlike a DP, we're trying to get your response on that count. Is it at par with a DP or
This is the case
or
under,
will it amount to compliance with the principles of natural justice? That notice and opportunity was granted to you.
Hmm.
You file your response, they take a decision. Is that enough or is there something more?
something more is required. Below so far, my case is,
Where do you get it?
maybe I should come to page. Let me, or 2 or 3 pages actually, then I should come to the. Page,
Because unlike a DP where we are guided by some statutory rules, which statute only provides for an inquiry.
so much for an inquiry.
Inquiry in case the disciplinary authority is not satisfied with your response. If they are satisfied, better ends there. But the DP will be dropped. But if they are not satisfied, they cannot take a decision straight away. They have to hold an inquiry, give you an opportunity from the starting to the end
Pardon.
to reasonably defend yourself.
Now, below, in the meantime, Railway Board has framed a rule. And as per that rule, below, a personal hearing is essential
For blacklisting,
for blacklist.
where is it?
I gave it to a lot of people, but this judge.
Last opinion,
Yes, I have to answer this question. Your lordship has asked me whether it will operate retrospectively or prospectively. The principles of natural justice is the essence of justice. So essence of justice cannot operate retrospectively or the prospectively. It is a declaration. Now, I will, so far this, no, Lord,
But that is not the general procedure. Judgment there is no date of a judgment unless the judgment specifies. But law has a date. Unless the law is declared to be having retrospective effect, all laws are prospective, unlike a judgment. Judgment, unless it says, suppose the famous case of Muhammad Ramjan Khan, where a specific date was said, you don't furnish a copy of the inquiry report,
that is, yes.
That is from a particular date.
That is what I.
that
would like-
saves the earlier DP which has already occurred because it will
Yes.
open a huge floodgate.
Yes, that
But,
is what I.
But that is only the exception. Otherwise, judgments are all given, all are entitled for the same benefit.
No, that aspect I would like to say, when it pertains to some procedural aspect. Say whether the representation has to be given or not, whether non-submission of a representation amounts to principles of natural justice or not. That was the point involved in the Ramjan's case. And then they, in that case, it was decided all right, when it representation, if the representation is not given, then all right, it should be considered that it is not principles of natural justice. Now, prior to that judgment, hundreds or thousands of cases
Yes,
were,
yes.
thousands of cases
So they
were.
have fixed a particular date.
uh,
In fact, it was clarified in MDECIL, I think.
So that is what.
91, some date of
Yeah.
91.
Similarly, if your lordship consider the Goloknath case. Though it was overruled subsequently, in the Goloknath case also, it was to say that if a property is taken away without due compliance by violating the fundamental right, that will be illegal. But prior to that judgment of 1967, thousands of lakhs of acres were taken away. So that is why that was stated, no, you should not, it should be operated retrospectively,
Prospective.
prospectively. Similar some other cases you follow.
No, but this is a kind of a
This
statute.
is
it's
a case
no,
where
no,
the essence of justice.
The notification which you placed of 9/11/2022, is there any indication that it will have retrospective effect?
But clause 19, that would clear the position.
1919.
19, third page. Specifically stated, ma'am, from when it would operate.
Department proposal received 19. Not 19.
19, my lord. Third page of the document. Department proposals received.
10 days from the date of issue. Shall be dealt as per. Okay, yeah, date has been specified.
So one thing was whether the principle and
Had it been a matter after this date, then there's no
no
problem.
problem.
But
the
this is a
matter
matter before this date. But they have also realized the requirement.
requirement.
But having realized in 19, they have also clarified
Clarify.
that earlier cases will not be governed by this notification. In spite of that, if you want to make out a case, no, these are ingrained principles
Yes,
of law.
that is what I.
You cannot do away with the principles of natural justice.
Because natural justice is the essence of justice. Essence of justice. And these circulars was issued.
But any judgment which you find that the same rigors should be followed or
No,
even
one
in
thing
the
is
case
Miller-
of blacklisting.
Miller, principles of natural justice varies from case to case. My case may be different from the other's case. So no straightjacket formula can
No,
be
no.
got.
Is there any case law on blacklisting?
Yes.
On blacklisting, which has said that a mere issuance of notice is not enough. It requires something more.
Oh.
Have you got anything on
My
that?
last occasion that I referred.
Because Raghunath Thakur has said for a hearing.
Yes, sir.
What is the meaning of hearing?
If I may,
We'll come back to it.
About UMC technology. Let me use this paragraph. Then probably I think I'll be able to establish my case. I should try to. No paragraph. Page 17. No, I have read page 17. Page.
What was the language used in the first case, erosion equipment?
Yes, that is the first judgment. That is a very good judgment.
No, but was it? I don't think it was said in many words.
No, that
So
is
it has
the
based on the
problem, the
principle.
precise judgment. Lord. That is paragraph 12 and 15.
Erosion.
Again, judgment is with your lordship. 75 1, 75,
Paragraph.
75 one SSA
Yes,
page
sir,
7,
we have this.
paragraph 7 or 12, 15 and 19. Hmm. How this thing came? Article,
No, those we are aware that it amounts to even to the expression involved, used is a civil death,
yes, sir.
civil death. But what is the concept, what is the procedure laid down? It is not said.
The
nothing in
procedure
12. Nothing in 12.
No, so for the principles of natural justice is concerned, judgment, no procedure has been laid down. The only thing that there is a case of civil death, adequate opportunity of being heard. So that he can represent his case properly. It is left open to the person concerned, to the body who will decide it.
If you can get some clue in paragraph 20 and 21,
Yes, sir.
other consequence, come to 20,
Where a state is
no,
dealing with
20, blacklisting.
nothing. Blacklisting has the effect of preventing a person from the privilege and advantage of entering into the lawful relationship with the government for purpose of gain. The fact that disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent it.
Yes, then come to next.
That is the only thing. And
Then next, come to 21, come to 21,
he is to put his blessing.
21,
21.
come to
With
21.
regard to the case of petitioners, it is made clear that the authorities will give an opportunity to the petitioner to represent their case, and authorities will hear the petitioner as to whether their name should be put the blacklist or not. This is made
Yes.
clear.
Yes, none, rest are not relevant.
Decision makes,
The rest is not relevant. So
this
you need
is-
to give an opportunity of hearing.
Yeah,
What is the meaning?
the meaning of the hearing. But hearing means to give an opportunity to represent his case properly. By giving all. And that is, and the railway board circular has made it clear, this hearing means personal.
Have you got Raghunath Thakur?
Raghunath Thakur. Yes, Raghunath Thakur. is there.
Small judgment, I think,
Small, Sabyasachi Mukherjee.
yes,
Raghunath Thakur.
yes, 89, I think,
89 1 SCC 1229.
Yes. Please, I think there is something else, in your favor.
The order dated 25th March 1988 of the collector is under challenge in the appeal.
No, you don't need to read the entire judgment. You read the principles. The small judgment, second page, I think, there is something.
Paragraph 4. Indisputably, no notice had been given to the appellant of the proposal of blacklist to the appellant. It was contended on behalf of the state government that there was no requirement in the rule giving any prior notice before blacklisting any person. Insofar as the contention that there is no requirement specifically in giving any notice is concerned, the respondent is right. But it is an implied principle of the rule of law that any order having civil consequence should be passed only after following the principles of natural justice. Principles of natural justice. And it has to be realized that the blacklisting any person in respect of business venture has civil consequence for the future business of the person concerned. And in any event, even if the rules do not express so, it is an elementary principles of natural justice that the parties affected by any order should have right of being heard. Should have right of being heard and making representation against the order. Against the order. In that view of the matter, the last portion of the order insofar as it directs the blacklisting of the appellant in respect of the future contract cannot be sustained sustaining law. In the premises that the the portion of the order directing that the appellant be placed in the blacklist in respect of future contracts under the controller is set aside. So far as the cancellations of the bid of the appellant is concerned, that is not affected. This order will, however, not prevent the state government or the appropriate authorities from taking any future steps for blacklisting the appellant if the government is so entitled to do so in accordance with the law. That is, after giving the appellant due notice and opportunity of making representation. After hearing the appellant, the state government will be at liberty to pass any order in accordance with the law in the reasons thereof. We, however, make it quite clear that we are not expressing any opinion on the correctness or otherwise the allegations of made against this appealing. Like here, of course, in my case also, so for the impugned order is concerned, so no reason whatsoever has been applied.
Let us come to the impugned order.
Annex of 12, page 53. No reason whatsoever. Page 53, Miller.
Yes. Annex 12,
Annex of 12.
2910.
2910. Mesa Satyansa Avenue was served with the memorandum of statement of charges for banning the business dealing with them for malpractices committed by them or getting work related to the order dated such and such through the forged documents. Reply of the memorandum submitted by Messrs. Sumkam Abhiyantik JV by their letter dated 10/9/21 has been considered in detail by the competent authority who has concluded that Messrs. Sumkam Abhiyantik has indulged malpractice. No reason whatsoever.
No, reason is there. And you have also been served with a notice that you have committed malpractice by your forged documents.
Yes. So, yes.
And reasons need not be so elaborate in the order if it's contained in the file. Reasons are there, but we are on a different question altogether. That only because they are not satisfied with the reply which you have filed, can they straight away come to the decision? Or
That
there is a
given
further requirement of giving a person hearing?
Yes. Yeah, for this reason, we are not in a position to submit your representation.
No, read further. Reply to the memorandum.
Therefore, would be decided by the Ministry of Railway Board.
Paragraph 2 again.
Huh?
Paragraph 2 again.
Two again, the reply to the memorandum submitted by Messrs. Sumkam Abhiyantik JV by their letter number such and such dated 10/9/21
Has been considered
have been considered
in detail.
in detail by the competent authority. Who has concluded that Mr. Sumkam has indulged malpractice. That was their conclusion. So at least they should have given opportunity. You see, you have come on all this. And I have submitted my detailed representation. What way I was deceived.
It is exactly in this point we want to get your response. Suppose just compare this with a disciplinary proceeding vis-a-vis a workman or a person in service. A charge memo is given to him. He replies. They are not satisfied. Like this. Can they straight away dismiss him?
No.
Or take any or impose any penalty against him? No.
That
Yeah.
is-
They have to hold an inquiry.
that was an- And this because in the Reed versus Berlin also these things were mentioned.
Now, if there is a requirement of holding an inquiry, at least a semblance of an inquiry, is there anything, in any case clause stating that in such a case, at least you should have an inquiry so that the allegations against you are prima facie proved, established.
Yes. So far, these are the allegations against you. And you are to
See, they-
establish.
They are making the allegations against you.
Hmm.
The initial burden is upon them to prove.
Yes.
They have given you a scope to say, these are the allegations, what do you say? Obviously, you say that I have not
No, no, I-
committed, I have not committed anything, these are false allegations.
False allegation.
Now
Then
they are
that
not-
will fit to that.
Now they are not satisfied. Can they straight away pass an order of
No.
penalty, adverse order, or is there any requirement like in a disciplinary
But
proceedings?
Evidence Act is concerned, my lord. I lodged an allegation against you. You have denied this allegation. You have not admitted this allegation. Here in this is Reed versus Berlin.
But will that seem rigorously applicable in a case of blacklisting, just as in a case of DP, disciplinary proceeding? That is where, if there's anything you can assist, any case law, that both are held to be at par.
So for disciplinary proceedings and blacklistings are gone.
The requirement of law.
Exactly, there is no such case, exact word, but it can be inferred. So when the authority came to a conclusion that you have done something wrong, then the authority concerned should give an opportunity that what is your opinion about these things? And you please establish that, that you are not guilty. Now here, my lord, they have lodged allegations. And I submitted detailed representation. My representation, according to them, my representation was considered by the competent authority. And competent authority was not satisfied with my representation. And so they will not come. But why they are not satisfied? There might have some difference between you and the group. So I should give an opportunity. That you see, you have said so, we are not satisfied. So what is your statement? What for stand?
We'll come back. Yes, Sharma, you say.
My lord, issue, the question.
Have you come
Yes,
across?
my lord, it's a covered issue, my lord. Long back decided by the apex court, my.
Which case?
Gorkha Security Force and Patel Engineering. I'll place the judgment. No personal
Hotel
hearing. is there.
engineering.
Directly said, my lord, directly said. Before the honorable apex court that whether personal hearing is required to be given, honorable apex court categorically stated, my lord, not required. Both two judgments.
Gorkha
I'll
report,
place this.
Gorkha report is 18, and that was referred in the year 2021.
So Gorkha, you might have a case, but Patel engineering where?
Yes, my lord,
Okay, we'll come back.
long back.
Lord, my friend is relying upon Gorkha Security Service. Now, I'm not in Gorkha Security Service. Helmet is okay. Whatever did that.
What is the citation?
That citation is 2014 960 105. Now, let's hear what happened. Focus notice was issued. At paragraph 5, your lordship will find the focus notice. And whereas by the above omission, the firm has not only failed to provide minimum wages. Minimum wages was not provided to the worker. Minimum wages and extra extend the statutory benefits and abide by the labor laws, but also failed to provide that satisfactory service and failed to submit the required information documents, and when called upon and also being required prerequisite under the tender terms and conditions, and have tendered this hospital at the risk of deputing less security personnel that too without,
You can skip this
No,
allegation. What is
Yes.
this?
no, against that, not here's, against that. then that's it.
Against that, they had
Now again,
submitted response.
so they submitted response and they said, no, we are not satisfied.
Hmm.
All these things are done and the impugn order was passed.
Hmm.
Impugn order of blacklisting was passed.
Hmm.
Now we are lucky, probably my learned friend will rely upon paragraph 20.
Hmm.
There is no dispute. No dispute about the requirement of serving show cause notice.
Hmm.
We may also hasten to add that once a show cause notice is given, an opportunity to reply to the show cause notice is afforded. It is not even necessary to give an oral hearing. The High Court has rightly repudiated the appellant's attempt in finding fault with the impugned order on this ground. Such contention was specifically repelled in practice engineering. So what my lord wanted to focus that when a show cause notice is given and you have submitted your reply, so no further personal hearing is required. So here in this case, Lord, yes, by this was what are the consequences? Civil consequences is there. The quantum of the consequences, the magnitude of the consequences. Here, a penalty may be imposed. Forfeiture of the security deposit may be imposed. Some damage may be imposed. If all these things are done, are done, then only by giving a show cause notice and calling upon the delinquent to submit his reply, and considering that this is sufficient. But when a person is blacklisted, its consequence is dire civil consequences. It amounts to civil death.
Gorkha is not a case of blacklisting.
It was a case of blacklisting.
Then
It was a case of blacklisting, but while blacklisting, the matter, the show cause notice was given. And in that show cause notice, the proposal of imposing the blacklisting was not incorporated. And thereafter, this impugned order was passed by stating that you have been blacklisted. Now, you will have to come to page paragraph 21. Next paragraph.
Hmm.
Contents of the show cause notice. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind serving of show cause notice is to make a noticee understand the precise case set up against him, which has to meet. These would require the statement of imputations detailing out of the alleged breaches and defaults, and he had committed, so that he gets an opportunity to rebut the same. Another requirement according to us is the nature of action proposed. Nature of action proposed to be taken for such breach. That should also be stated so that the noticee is able to point out the proposed action is not warranted in given case, even if the defaults or breaches complained are of not satisfactory explained. Even if that should be given to the noticee able to point out the proposed action is not warranted in a given case, even if the defaults, breach complained are of not satisfactorily explained. When it comes to the blacklisting, the requirement became all more imperative. All more imperative, having regard to the fact that it is earliest possible action. So, punishment in
Yes,
so imposition of punishment is to be, when you are imposing a serious punishment, my lord, then the natural justice, scope of natural justice will be more widened. And even if you more widened. And that has been clarified in the subsequent cases, my lord,
read 34, the last para.
paragraph 34. Miller, yes, I will come to 34. Let us come 29, then 34. No doubt, paragraph 29. No doubt, rules of natural justice are not embodied rules, nor can they be lifted to the position of fundamental rights. However, their aim is to secure justice. Their aim is to secure justice and to prevent miscarriage of justice. And that is why what I would like to submit just to what the notification that was issued whereby the personal hearing is required. This will be applicable for me also, Lord. No doubt, the rules of natural justice are not embodied rules, nor can they be lifted to the proposition of a position of fundamental rights. However, their aim to secure justice and to prevent miscarriage of justice. It is now well-established proposition of law that unless a statutory provision earlier specifically or by necessary implication exclude the application of any rules of natural justice, the exercise of power prejudicially affecting the another must be in conformity with the rules of nature. Now, let me, you also wanted me to read paragraph 34. For the aforesaid reasons, we are of the view that the impugned judgment of the High Court does not decide the issues in the correct perspective. The impugned order dated 11/9/2013 passed by the respondent blacklisting the appellants without giving the appellant notice thereto is contrary to the principles of natural justice, as it was not specifically proposed, and therefore there was no so-called notice given to this effect by taking action of blacklisting against the appellant. We therefore set aside and quash the impugned action of the blacklisting of the appellant. The appeals are allowed to the
Mr.
extent-
Sharma, it was interfered with.
It was interfered with because there was no proper show cause notice, my lord. The first and foremost requirement of a show cause notice is that the show cause notice should set out the grounds based on which the action is proposed. And the second thing is that it should clearly state that the purpose of issuing the show cause notice is to ban. In this case, my lord, in the case of Gorkha Security Force, that purpose was not mentioned in the show cause notice. That is why the Honorable Apex Court said that it was not a proper notice. On that count, it was set aside. And both Patel Engineering also, both the cases are cases
No,
of,
if you read 34 properly,
yes,
it is not only because of improper notice, he said that it is contrary to the principles of natural justice.
yes, that is why it is contrary to the principles of natural justice. Lordship has to read the entire judgment, then it will be clear, my lord. I've read it. Because the notice was not proper, my lord,
See, when ultimately it has been interfered with,
interfered with.
how can you say that this judgment will be applicable in your case, or you gain anything from this?
My lord, what
This has gone on a different tangent, different digression on the contents of a show cause notice. We are on a different line, question altogether.
I am,
Rather, if you read paragraph 32, the prejudice argument. I think we will get some light in paragraph 32, Mr. Dasgupta. It's a long paragraph.
when it comes to the action of blacklisting, that one, my lord,
No, the prejudice
the
argument,
prejudice
32.
argument, it was sought to be argued by Mr. Even if it's accepted that the so-called notice should have contained the proposed action of black, no prejudice was caused to the appellant in as much.
Same judgment, paragraph
Yes.
32.
As much
It
as
doesn't say? Gurkha.
according to action, blacklisting was, yes, Malad, this clarifies, Malad. According to him, even if the action of blacklisting was not proposed in the so-called notice, the reply of the appellant would have remained the same. On this premise, the learned additional Solicitor General has argued that there is no prejudice caused to the appellant by not mentioning the proposed action of blacklisting. This is the case, Malad.
You read.
He
That is his
argued,
argument.
he argued that unless the appellant was able to show that non-mentioning of the blacklisting as the proposed penalty has caused prejudice and has resulted in miscarriage of justice, the impugned action cannot be nullified. For this proposition, he referred to the judgment of this court in so-and-so versus so-and-so. From the ratio laid down in so-and-so, it is explicitly clear that the doctrine of natural justice requires supply of a copy of inquiry officer's report to the delinquent if such inquiry officer is other than the disciplinary authority. It is also clear that non-supply of the report to the inquiry officer is in the breach of natural justice. But it is equally clear that failure to supply a report of the inquiry officer to the delinquent employee would not ipso facto result in the proceeding being declared null and void and the order of punishment non-est and ineffective. It is for the delinquent employee to plead and prove that non-supply of such report has caused prejudice and resulted in miscarriage of justice. If he is unable to satisfy the court on that point, the order of punishment cannot automatically be set aside. At the same time, however, effect of violation of the rule of audi alteram partem has to be considered. Even if hearing is not afforded to the person who is sought to be affected or penalized, can it not be argued that notice would have served no purpose, or hearing could not have made difference, or the person could not have offered any defense whatsoever? In this connection, it is interesting to note that under the English law, it was held few years before that non-compliance with the principles of natural justice would make the order null and void, and no further inquiry was necessary. The recent trend, however, is of prejudice. Even in those cases where procedural requirements have not been complied with, the action has not been held ipso facto illegal, unlawful, or void unless it is shown that natural
Non-observance.
had prejudicially affect the applicant. From the aforesaid decisions, it is clear that though supply of report of the inquiry officer is part and parcel of natural justice and must be furnished to the delinquent employee, failure to do so would not automatically result in quashing or setting aside of the order, or the order being declared null and void. For that, the delinquent employee has to show prejudice. Unless he is able to show that non-supply of the report of the inquiry officer has resulted in prejudice or miscarriage of justice, an order of punishment cannot be held to be vitiated. And whether prejudice has been caused to the delinquent employee depends upon the facts and circumstances of each case, and no rule of universal application can be laid down. When we apply the ratio of the aforesaid judgment to the facts of the present case, it becomes difficult to accept the argument of the learned. This is in a different context altogether, my lord. I've gone through the entire judgment many times, my lord. If
The
required,
judgment is before us.
yes, my lord. What it says, my lord, the so-called notice was
You don't
bad.
need to read the judgment number of times. If you
Yeah,
understand.
yes, my
See,
lord.
his argument was there. What was the argument of the learned additional solicitor?
In the first instance, we may point out that no such case was set up by the respondents that omitting.
See the fourth line, fifth line. According to him, even if the action of blacklisting was not proposed in the so-called, the reply of the appellant would have remained the same.
Remain the same. So the Supreme Court, Honorable Supreme Court held that the so-called notice was bad. If the so-called notice was bad, then compliance of principles of natural justice doesn't arise, because it goes to the root of it, my lord. That was the ratio laid down in this case with regard to the so-called aspect of so-called notice. But so far as oral hearing is concerned, in paragraph 20, it has categorically stated, my lord, that no oral hearing is required. Even if we leave aside this judgment, my lord, I'm forgetting this judgment for the time being, my lord. I'm coming to the judgment of Patel Engineering, my lord. Reported in 2012, 11 SCC 259, 257, my lord.
Yes. 2000?
2011, 2012, 11 SSC 257.
Two, two, five,
257. I'm keeping this judgment aside, my lord. I'm not even
portrait
relying. if
engineering.
required.
Let's see.
Paragraph 38.
You have a copy?
Yes, my lord. I have it. My lord. The same argument was taken in this case also. my lord. Paragraph 38, page 268. I'm relying these two judgments on the aspect of giving personal hearing only. Coming to the submission that R2 ought to have given an oral hearing before.
Just a minute.
This was reiterated in Gorkha, my
Paragraph
38,
13,
38, my lord.
38.
38, last paragraph.
Yes, please read.
Coming to the submission that R2 ought to have given an oral hearing before the impugn order was taken, we agree with the conclusion of the High Court that there is no inviolable rule that a personal hearing of the affected party must precede every decision of the state. This court in so-and-so versus so-and-so held, so even in the context of a quasi-judicial decision, we cannot therefore take a different opinion in the context of the commercial decision of the state. The petitioner was given a reasonable opportunity to explain its case before the impugn decision was taken. This was reiterated in Gorkha Security. I'm relying these two judgments only for the purpose of showing that a personal hearing is not required. The subsequent judgments which I had placed before your lordship on an earlier occasion, my lord, on the first day when I had argued, it categorically states, my lord, that a show cause notice is required to be given. First of all, the show cause notice should mention two things, my lord. Number one, the intention to ban. Number two, the grounds based on which the action is proposed. And the third thing, an opportunity to reply should be given to the person concerned, the affected person. All these requirements have been complied with by the railway authorities, my lord. And in fact, in his reply to the show cause notice, he had admitted his fault, my lord. I placed the reply to you before your lordship on the earlier occasion. He had admitted everything, my lord, that he had submitted.
Merci. Yes, where?
Page 43 of the writ petition, my lord. 48, ma'am. 48, sorry. 40. From paragraph 2 onwards, it would be relevant, ma'am. I may skip the first two paragraphs. May I read, ma'am?
Yes.
That in the month of March 2019, one person introduced himself as the proprietor of so-and-so, which deals with railway track products and permanent way works, and expressed his desire to sell his company with one work completion certificate from so-and-so. After discussion, the Messrs. So-and-so decided to take over the so-and-so. Accordingly, the said proprietor of this Messrs. So-and-so executed an agreement with Messrs. So-and-so on 1/4/2019 in presence of witness. The Messrs. So-and-so on good faith take over the said Messrs. So-and-so by paying the consideration money as negotiated between them, and the company was taken over by 1/4/2019. That the chief engineer on NF Railway, Maligaon, issued a e-tender for so-and-so. So I may skip this paragraph, my lord. It just states what was the nature of the work, my lord. I'm coming to paragraph number 4. That, sir, to participate in the e-tender process, Mr. Samkan and so executed a memorandum of understanding and joint venture agreement on and as Mr. Samcon joint venture. After completion of formalities of joint venture with Mr. Samcon Infra Ventures LLP, the tender was submitted for the aforesaid work by the joint venture. The tender was submitted on good faith with all bona fide by enclosing the required documents validly for a period of 60 days from the date of closing as per tender terms. That's the bid validity period of our submitted offer was valid for 60 days with effect from and the tender process was not completed by the authority within the same period. Therefore, the Deputy Chief Engineer NF Railway Jogi Upa issued a letter on requesting all the bidders to extend the validity of the tender for another 30 days. The said letter was communicated through email on On receipt of the email, we informed the authority that we are not interested to proceed with the tender process due to some technical problems, and therefore we did not submit any offer for extension of a tender after offer bid. We personally informed the authorities issuing extension letter that our tender may be allowed to withdraw for some technical difficulties and our company may be treated as non-participation in the process. That's on the other hand, although the message was taken over in the month of April 19, but the person who introduced himself as a proprietor of failed to furnish with the balance sheet and the other necessary documents to us. Thereafter, on inquiry, we came to learn that the said company has already been taken over by Messrs. Samcon Infra Ventures Limited in the year 2017, and the alleged sale is done by a third party by committing fraud to us. We did not have any knowledge about the same, that we have been cheated by third party. That's we use the documents of Messrs. On bona fide and in good faith. We had no intention to cheat the railway in any manner. While we get the smell of fraud committed with us, we refrain ourselves from submitting the prayer for extension of tender and requested that the authority cancel our tender offer and wish to come out for the tender process for the above para 3 mentioned tender. Therefore, we have not committed any misconduct, forgery with the railways intentionally as alleged. We have not taken any undue benefit by using any false documents. We have not submitted any fake documents intentionally. These are all qualified statements, my lord. Admitted that he has submitted all these documents before the railway authorities. Alleged, we assure and undertake to be more careful in the future before making any deals with any company and also in taking part in the tender process. It's an admitted fact that these documents were submitted before the railway authorities, which turned out to be fake.
Read the contents of paragraph 7 again.
That, sir, we use the documents of Messrs. Singhania Associates on bona fide.
Using is admitted,
Yes, admitted.
but used on what? On bona fide and good faith.
Now,
Then see the next line. We had no intention to cheat the railway in any manner. While we get the smell of fraud committed upon with us, we refrain ourselves from submitting the prayer for extension of tender and request the authority to cancel our tender offer. And we used to come out of the tender process. This is in connection with a fresh process. Now they are with the blacklisting.
now
They are
this
not
is-
denying the use of the documents.
that was the allegation against them. This is an alibi set up by them in response to the so-called notice.
So
and
if you
railway-
already come to a finding of guilt, then there is no requirement of any criminal procedure or anything.
No,
You have the allegation, you are guilty, punish them.
that we
That
have
is
not-
what you are submitting, Mr. Sharma.
No, that is not my intention, my lord. That is not what I'm
That
submitting.
you have already ruled on their intention also.
No, this
It's
is,
upon you to prove.
no, this is,
They may be guilty, but you cannot hold them guilty like this.
no, we have not held like this.
You have held,
If I may,
you have added words.
this is my
You said
submission.
they have qualified their state. Of course they have qualified. No, but whether this letter
No.
is correct or not, we are not at this stage.
This decision, my lord, to black,
If you argue with an intention, with a prejudiced mind, it's not going to
no,
help
no.
us.
that is not my case.
And
What
this is the document they have annexed. They have said this, yes, it was used. Whether this projection is correct or not, that's a different purpose. You may say that whether it's correct, but you have already come to a finding. No, they have admitted of use, and they are now saying that that is not what is the meaning of this.
What I'm saying, my lord. I'm saying. this
See,
is the-
at this stage, we have to neutrally see the case for both the parties. If we see with a prejudiced mind, closed mind, we'll not be able to do justice to either of you or him.
My lord, what I'm saying, my lord, the allegations in the show cause notice was not proved based on this reply to the show cause notice. There were other evidence based on which the allegations were proved, my lord, and those documents I've already annexed. I'm placing this show cause notice only to impress upon your lordship that there is some sort of an admission on the part of the petitioner. I'm not saying that this show cause reply
The
proves this
admission is only to the extent of use of the document.
use of the document.
They have not said, no, not you,
Yes,
somebody else has implanted it.
That is what I'm
If
trying
you
to.
read the last
Yes,
paragraph,
it's
eight,
qualified. It's qualified.
paragraph 8, they have said, straight away said, we have not committed any fraud. And if this document, since we have come to our knowledge is fraud document, we wish to withdraw from the tender process.
That withdrawal, my lord, where they have stated, when they have stated before the authorities, I don't know, my lord, that withdrawal is not there, that,
But they have admitted in the affidavit.
my lord. And secondly, my lord,
They have
the documents based on which these allegations have been proved, my lord, those documents I've already annexed in my reply, my lord.
Let's see.
And the authority, competent authority has
Here, your page.
page from I'll place only the relevant one, my lord. This is to, my lord, page 27. Annexure R8. Running page
Your
71.
1st May 2022.
3919, my lord.
19. No. The affidavit.
Affidavit, in my affidavit.
1st March 2022.
First March, my lord, page
Is it Kinduram?
Hinduram, yes.
First
Yes,
March,
deponent is Hinduram, my lord.
1st March 2022. Same date, this affidavit.
Uh,
Date.
14 February 22.
First
Probably, my
Mar-
lord.
It was, I think, registered on 1st March.
First,
1/3/2022. 1/3. 14, maybe it was served upon you, but it was filed on 1st March.
probably filed on first.
You note the official date also. It is easier for us to have a same date. You are correct, it was notarized on 14th February,
14, my lord.
But
Date of filing,
presented on 1st March.
first.
Yes, which page?
Page 7, running page probably 71, my lord. The internal
Internal?
page is 27, annexure R8.
27.
This was the document letter issued to Messrs. Singhan.
72.
Is it dated 3rd of
3rd of
September?
September 12,
Internal running page is 83.
83. This
83.
to ascertain the, my lord, genuineness of the document submitted by the petitioner before the railway authorities in connection with the tender. This letter was issued, my lord, to Messrs. Singhania and number 2, the chartered accountants, my lord. My lord,
Dear Sinania, what is your name?
Avijantri.
And where is this relevant?
My lord, Singhania owned probably Samkan. They had entered into a joint venture with Samkan LLP and
A.
Avijantri, my lord. But
What is-
Samkan was probably owned by Singhania. And Singhania had not signed the documents which transferred Samkan to Avijantri, my lord. To prove that that action was, my lord, a case of, if I may.
There is no relevance to the petitioner, no reference.
This is, my lord, this is issued to so and so, and what we sought for was, with reference to the above, it is requested you to submit the genuineness of the following certificates. Number 1, affidavit of sole proprietorship, certificate, certified true copy of resolution passed, agreement, annexure A, money received, no claim, and certificate. Now, they had, my lord, submitted their reply.
Who there means?
The first, my lord, the chartered accountant, that reply, lordship will find in page 29. Eighty-five hours.
Running page 85.
85. It says, my lord, that my client has received a letter from your end requesting for verification of
Client is Sinhania.
Singhania.
So what is the connection with the
The
petitioner?
connection here is, my lord, Messrs. Avijantrik had entered into a joint venture with Samcon. And he says that he had purchased over Samcon, my lord. But Samcon belonged to Singhania and Associates. Singhania and Associates were the owner of Samcon, my lord. And if he had purchased it, then Singhania and Associates, my lord, the person concerned of Singhania and Associates, would have signed the sale deed. It was found that the signatures were forged, my lord, in that document, the sale deed, which they had submitted. That is how Singhania comes in, my lord. Those are forged signatures of Singhania. It says, my lord, that my client had received a letter from you and requesting for verification of the genuineness of certificate against name of work so and so.
Though we are not required to go to the exact allegation against Mr. Dasgupta, what is the allegation? Because paragraph 5 is something very serious. At page 87. Read 87
87,
of your affidavit, internal page 31.
31. Paragraph 5, my lord. That my client is grateful towards you for intimating him about the said issue and also for verifying the genuineness of the said document. My client holds a long-time relationship with you, your esteemed office. Keeping the said relationship in mind, it is once again reiterated that my client has no relation with the said perpetrator, namely Avijantrik.
Is the petitioner, isn't he, Avijantrik?
Yes, my lord.
And that
And that all the document certificates are forged and fabricated. Therefore, it is requested of you to refrain yourself from entering into any commercial transaction.
read the earlier paragraph also, it's very serious.
Serious, my lord.
Earlier paragraph.
That the said Avijantrik so and so has never taken over the said company under the name and style of Messrs. Singhania Associates, having its registered office at 5 Clive Road so and so so and so. My client had never entered into any agreement with said so and so private limited, the said proprietor with perpetrator with the sole intention of acquiring the said tender has used my client's name in trying to deceiving you as well as my client by using these fabricated and false documents. Even the documents, my lord, they have certified.
And 6, my client would like to inform you that they are taking stringent action.
Yes.
Against
Thereafter,
Avijantrik.
we filed FIR also. And the documents which we had forwarded to them for verification, internal page 33, my lord, on the body of the documents, the endorsements are there, my lord, that these are fake. After verification, it is found that it is not genuine and we are not concerned with this pad. This certifies taking over of Singhania and Associates. Then thereafter, all the documents which they had submitted in relation to the tenders were forged and fake, my lord. And the competent authority had taken the call on the show cause notice on the basis of the evidences before them, my lord. Now, I have placed before your lordship on the first occasion when I argued the matter that the only requirement in case of a blacklisting is that, my lord, there has to be a show cause notice. The show cause notice should indicate 2 things, my lord: the intention to blacklist, and number 2, the grounds based on which the action is proposed. And thirdly, the person concerned, the aggrieved person, is required to be given an opportunity to show cause, my lord. All these aspects were present in the show cause notice. In fact, he had replied, I have shown to your lordship that the reply. Thereafter, the authorities had taken a call. And so far as the aspect of personal hearing is concerned, my lord, I have placed this the cases of Gorkha Security and Patel Engineering, my lord. I'm relying on those two judgments only for the purpose of bringing home the fact that a personal hearing is not required in a blacklisting matter, my lord. It's not equivalent to a departmental proceeding, my lord. And so far as setting aside of the order in Gorkha Security is concerned, it was only because the SOCO's notice was non-est in the eye of law, because it was bad in view of the fact that the SOCO's notice did not mention that the intention was to blacklist. That is why the blacklisting order was interfered with, because it was not a notice in the eye of law. These are basic, and that document which my learned senior placed, my lord, document issued by the railway authority, that is prospective in nature, my lord. And even on marriage, that procedure doesn't apply to him. There are certain, my lord, conditions laid down for application of that procedure, my lord. The document.
What is the exact allegation?
Allegation it's in the scope.
845.
45 and 46. 47.
It starts from 45, no?
Yes.
Statement of charges. Let us read the statement of.
Statement of charges.
A tender, I so and so was invited through IRES for execution of the work, that is linking of so and so, so and so, so and so. If I may speak, keep this paragraph.
Yes, yes. This is the tender.
Yes. As Samcon Avijantrik joint venture, Chapaguri Road, North Bongaigaon, PO and District Bongaigaon, so and so participated in the above mentioned tender and uploaded the documents, that is affidavit of sole proprietorship, certified copy resolution passed in the meeting of the board of directors, agreement of taken over of business of Singhani Associates by Avijantrik Infratech Private Limited, money received, no claim of Singhani Associates for using credentials by Avijantrik Private Limited as a supporting documents towards eligibility criteria. Later on verification, it was found that the above documents submitted by the contractor were fake. In the light of above, has clearly established that Messrs. Samcon Avijantrik Joint Venture, Sapaguri Road, North Bongaigaon, so and so, committed the grievous offense with malafide intention and tried to cheat Indian Railways for getting work through forged document.
The element of forged document has not been denied. The only question is that they have denied that their involvement in forging the document. They have denied that they are involved in forging, but use of the document per se has not been denied.
The call will be taken. Once the call is taken by the authorities, then the question of review in a judicial process would come before lordship. These orders are not challenged in marriage. That is it.
You're nipped in the bud. Nipped in the bud.
Okay.
Before you could even apply for the job, you have been blacklisted.
And Milord, I have also not participated in this tender.
No, you had intended to participate. You had submitted the bid. Were you working with the railways earlier?
Yes, yes,
You were.
yes. For a long time.
Depending on the tender value, my lord, credentials are
Long back,
required.
Milord. Now, Milord, what my friend is relying upon this Patel engineering case, paragraph 38.
Yes, let's wind up. Finish your argument. Patel engineering.
10 minutes. Patel engineering, Milord. Coming to the submission that ought to have given an oral hearing before the impugn order was taken. we agree with the conclusion that the High Court, that there is no inviolable rule that a personal hearing of the affected party must precede every decision. For each and every decision, personal hearing is not required. Personal hearing may require in some decisions. It is not that a universal rule, my lord, that no personal hearing is not required. Personal hearing will it depends on the facts of the case. You have alleged some allegation. We have stated, yes, we have used this document, but we was deceived by somebody. And actually, it was bona fide, my lord, we were deceived. If your lordship goes to my
But
reply,
you enter into an agreement with Sinhania,
Singhania,
then the document you have used.
the manner in
Now,
which I
can
have,
you say that you are not aware that the documents are forged?
no, my
Can it
lord,
be an automatic, some documents you received and you come to know that there is an agreement?
no, my lord,
Agreement will be preceded by many overt act of yours, meeting people, signing documents.
no, my lord, so
It
far
is
my
not something
reply-
that you find a certificate, then you act upon a certificate turns out to be forged. Now the documents which is forged, you are a party to that document
No, my lord, your lordship come to that paragraph, my lord.
and you have agreed on the forgery part.
No, my lord,
Had those documents not been connected with you at all, but you are simply using it. But these are documents are taking over Sinhania by you.
no,
Can that be done without your involvement?
my reply, if you have to go through my reply, my lord, what I wanted to say. My lord. That paragraph. Paragraph 2, my lord. That in the month of March 2019, one person introduced himself as a proprietor of Mr. Singhania Associate. He came, he said, it may be wrong, it may correct. my lord.
See, we are not here to make any comments.
Yes, yes.
But the requirement is not of Sinhania. Requirement is of you. They are not the bidder, you are the bidder.
No.
You need Sinhania's help to bid. So persons of Sinhania will not come to you. Rather, you will go to Sinhania. That's what a normal person will think, reasonable person's thinking. See, who's the bidder? You are the bidder. Aren't you the bidder?
Yes, I'm bidder, but.
You are the bidder. You intended to participate in the tender process.
Creating a JV, my lord.
That is it. Your
JV was created with the Singhania, no?
see, for the contract in question, by yourself, you are not capable. You wanted the assistance or joint venture with somebody else. Joint venture is not before us. They are not bothered with this matter. You are being blacklisted. So the normal presumption is that you will approach your partner. They will not approach you. Your version that somebody from Sinhania had come, that may be difficult to accept. Because ultimately, who is the bidder? We have to question who is the bidder. It's not Sinhania, it's you.
Abhijantik infrastructure.
That is you.
So what is my reply, my lord?
Just read that line.
But in the month of March 2019, one person introduced himself as the proprietor of Mr. Singhania Associate, which deals with the railway track product and permanent way work, and expressed his desire to sell his company with one work completion certificate from the container company, Corporation of India Railway Track. After discussion, the Messrs. Abhijantik Infratrack Private Limited. This is a prisoner. Well, Private Limited decided to take over Mr. Singhania Associate Company. Accordingly, the said proprietor, Mr. Singhania Associate, had executed an agreement with Mrs. Abhijantik Infratrack Private Limited on 1/4/2019 in presence of witness. The Messrs. Abhijantik Infratrack Private Limited on good faith take over and said Singhania Associate by paying consideration money as negotiated between them and the company was taken over by on 24/2009. That was my stand.
You had paid money to a fictitious person,
Yes, Lord.
and that person has filed a case against you.
So actually, my case was I was
What action have you taken? If you are deceived, have you taken any action against the person who had introduced himself to be a representative of Sinania? Did you lodge any police case?
Yes, Lord.
See, Mr. Dasgupta, we are not required to go into the merits of the allegation, but the matter has become such that allegations may also be relevant. What is the kind of allegation against you? Allegation of manipulating documents, taking recourse of fraudulent documents while participating in a tender process. And as documents you are not, the worst part is that you are not disowning use of the documents. You are only saying that we did not know those were false documents. But the documents, you are a part of making of the document. It is not
Lord,
something.
After all, this is a case. This is not we are not before your lordship for a trial. Only thing is whether the requirements of natural justice are fulfilled.
That of course is has to be answered.
Natural justice are fulfilled. Now, you have lost some allegation against me. I have submitted my reply. You were not satisfied with this reply. And you have just you imposed extreme
No,
punishment.
you are correct, but
Extreme punishment.
we cannot be.
Was it not necessary on your part to explain that you see we are not in a position to rely upon you? Not believe.
No, Mr. Azhar, you are correct, but as a code of equity, at times we have to see the relevant, the contemporaneous situation factors. Not that we cannot see or should not see. In a given case, yes.
Lord, in that case, Lord, may I pray for some?
It is not a
Allegation
case that some
proper.
other allegations have been attributed that you were not, some works of you have been done defect in a manner which is not proper. Now, this is a allegation of use of forged documents, which the use of the allegation which you have not denied. You have denied
In fact, Lord,
the part of forgery involved, but you have not denied the allegation of use of those documents.
So far, when I have come to know, I have withdrawn myself from the tender process.
No, this explanation is not acceptable. If those documents were something which was put in your hand, you are not aware of it. Now, these are the documents, you are the maker of the documents. It's an agreement you entered with Sinania. It's not something which is given by a third party that use this document. It's an agreement you have entered into with Sinania. Sinania themselves an agreed party lodged an FIR against you.
Lord, if your lordship come to pay.
Okay. We close it. Consider.
The one thing Lord, that I would like to tell your lordship, whether this impugn order was passed in the year 2000. It was passed.
That is 21.
When
21.
21,
In October 21.
29/10/21.
21, Lord, 4 years ban, Lord.
5 years.
5 years? 5 years.
No, it is October 21.
October 21.
It's hardly 1.5 years.
21 October. Can it be reduced proportionally by bona fide? So, yeah, that apart, when the railway authority has come with that document, is that personal hearing is required.
There are more to it, my lord. I have
Otherwise,
not
Lord, it will be
disclosed.
about-
We will consider that. If you hold against you, then we may give you a liberty to approach them. They'll consider.
Yes.
If as a primary or secondary authority, you will not like to interfere with this. It's up to them.
Let them take
Yes,
the
We
call.
can indicate that 2 years may be a sufficient time. And that is why we're asking, what is your credentials with the railways? Did you work with them before?
Yes, yes, we have done on so
Successfully
many
worked
work.
on works? Have you said anything? Have you said anywhere?
Yes, in our petition itself, we have taken.
Where? Tell us.
Paragraph 5 to some extent.
Five series, annexure 5 series.
Mm,
Page.
Page 8, Milord.
No. Paragraph 5, annexure 5 series.
No, page 5.
Annexure 5. Annexure 5. Want to know what are the works? Page 30.
Page
30 is one work, 3
Yes,
2021. This is you, isn't it? Avijantric
Yes,
Infratrack.
Yes. 2020, 21.
This is a letter of acceptance. Okay.
20,
6, 7, 7. And the work in question is 39.
Yes,
Mr. Sharma? Is the work in question where the entire case is based is 39? Is it 39?
Page 39, my lord,
Yes. This is the work, I think.
for which you was banned, my lord.
Yes. Now, for which the problem started? No. Is it not 39? Annexure 6?
The tender number C, con and JTL.
page 22, Milord.
What is 39 then? Huh?
A separate tender.
Where you had worked or what?
Oh, yes.
So did you get the work?
Yes.
No.
42.
Now, what is the relevance of page 39? These are the work in question.
Hmm.
For this work only you had formed the
No,
joint
so
venture.
far my present work is concerned, that was a tender dated 27/6/2019, Milord. Page 22. Thereafter, Milord, I have participated in so many tender process in the relay.
Page 22 is 19 work.
Yes,
Huh?
19. After 2 years, Milord, this was.
Page 22 is the work in question.
Yes.
And what about this, the other page?
These are
Page
different
39?
tenders. Hello, when we have participated in those tender process, Milord, some person lost an allegation against us before the that this was done. Then and only then was this inquiry was initiated. Our opposite parties, competitors. They lost an allegation, they have done.
Acknowledge page 22, based on which.
27,619.
In the order itself, the tender number is given.
And why the annexure 6 at page 39?
It's,
What are these?
statements have to be seen, my lord.
We have participated in this tender process.
Participated, my lord. That the petitioner begs to say. the
No,
opposite
it's participated, we have read that statement at page 9.
Page,
What is the relevance? Page 9, paragraph 6. Similarly, again, page 10, paragraph 7.
just- I got it, my lord. There are two other petitions pending before this honorable.
What
court.
has happened to those petitions?
Yes, my lord. These two.
Understood, what has happened to those petitions?
My lord, he did not get a stay order, my lord, the petitioner, and probably by now those have become infractuous. The
Because
petitioner,
those were
those tenders were rejected.
rejected
rejected,
because
no.
of this proceeding.
Because of this proceeding. Lord, on technical count, those were rejected, my lord, and probably these two particular tenders, my lord, are relating to those.
We have read it, we have just read that. Because paragraph 10 he has said 528921, 564821.
Yes. With
Have you
the
found?
departmental
Have
procedure.
you found?
Yes, yes.
Paragraph 10,
Yes,
two
yes,
two
yes,
petitions.
Yes. Found it. But I had appeared in those matters under the.
Okay, we'll close this. Third. The Dasgupta Learned Senior Counsel for the petition assisted by R. Ali. Whereas the railways are represented by the Vice Chairing Counsel Sri P. Sharma. Also, the hearing is concluded and judgment.
The only thing is that opportunity we can look at, so that we can make,
Which one?
so that we can make a representation for them.
For reducing the period. Let us see.
Terms of that particular. My case may.
Now that would be amounting to your reputation. If you allow,
No.
in spite of that circular, we might allow. This circular is not going to rely upon. Because as you said, if we, on the point of natural justice, it is an ingrained principles of law. On that, but whether it will extend to that giving a personal hearing or not, that's one question we'll have to address. And the second one, if we are not allowing your reputation, then this alternative argument that's taking into account your past conduct and your connection relationship with the railways in successfully doing works earlier, can the period of 5 years be reconsidered and anything else can be improved? So that's the rest of matters, any urgent matters are there? And that is only a connection or something very short. What is the matter? Renewal. Who's on the other side? Okay, that matter will take to any other urgent matters. Huh? Private market, yes. Short matter we can take, otherwise we have lots of matter pending. Okay. Okay, these two matters, others we may not take up.
Obliged, ma'am.
My lord, item 13, my lord, that relates to suspension of the registration for oil tank.
Sultan,
Yes, ma'am.
who was the hero of Sultan?
Salman.
Sure. Proprietor is Salman Khan.
Not here, my
What is his name?
son, ma'am.
Mr. Saiki is there. Who's on the other side? But we had protected you, so we had granted some interim order.
Another repetition, my lord, with regard to 5 vehicle lordship has passed order, but this relates to suspension of RC of another vehicle.
This transport department
Yes.
and oil. That will take some time. I don't think it will be possible. Be here if it's possible, otherwise we'll fix some date. We'll see that.
My lord, the forest department received person.
Where are they?
Then I have to wait.
No, is there any, you want to make some requests or what?
No, my lord, since I have the information that those matters will not be taken up today,
Today and tomorrow,
then interim is there, that is
we'll extend the interim order.
my lord,
Item number.
11 and
If forest department, somebody is there, then you can grant them some time for obtaining instructions. You try to have them, we will pass order,
My
you can
lord.
pass orders right now.
my lord.
At this court has been informed that the counsel for the department is yet to receive instructions, full stop para. Just after 2 weeks. Para, interim order passed there to continue till the next day ruling. এটা আহিলে নামটো ৰেকৰ্ড কৰি। Yes.
When the fact is, yes, there is two markets, also we count, really, both are cattle market.
Rosin, if it takes time, then
No, Milord, very short time, Milord. Only one point declared, Milord, now, whether in lordship, it will be admissible to change the days of the marketing. We are operating the market, they are operating, they are the private market and we are in the government market. We are paying this revenue to the government, they are none. They are enjoying it. Their land is their own as per their statement and the best Milord affidavit. So that is the question. And earlier, Milord, they have filed 3 cases, Milord, before lordship. And those cases, Milord, regarding 3 cases, they have made, Milord, their affidavit, Milord. That is WBC number 3779-2010, that was regarding for NIT, even it's NIT. And second case, Milord, 299/2014, that is regarding kiss money. Kiss money was not given to them, that is allowed by the also. And third case, Milord, of 2012-22, Milord, that is WBC number 4440.
Ali, you are paying for whom? 8 and 9.
And the private respondents, my start was running about 40 years only, and then Cottage is running. And they are residing about only upon kilometer distance. They are running this new high.
But
They
they
have no
are,
objection regarding their department. They are stand, my lord, they are trying to stand my market, same market. But that is the case, my lord. But they are fully aware of, my lord, our market is since long back, holding my lord market.
Are you agreeable to change dates? No.
No, my lord, that is not question, my lord, because there's no locus, my lord.
If it is a contested case, it will take time and of course, 3779, the division bench, this court had set aside a similar settlement, but the main major difference is this. In this case, an establishment of the market was put to challenge. Here, it's an existing market.
Yes, my lord.
And one more aspect, my lord, may I submit, my lord, one more aspect?
No, had it been a case that during your lease ended pendency of your lease period, somebody had started a market in the private land. You put the challenge, but it's a market which is existing for 40 years.
Our 1980, since 1980, I'm told.
There is panchayat market, my lord. How
Yes.
can he say that, my lord? And
If the panchayat does not have an issue, at the instance of a lessee,
Yes,
has the panchayat come? No.
only yes. And another thing, your lordship knows.
You knew very well there was a market.
New NIT will be issued next month. So again, June, in the last of June, will 1st July, new settlement will be issued, and another person will come.
But you knew very well there's a market existing. At the
Market.
time of taking a bidding for the lease in question, didn't you know that there was a market of a private market?
No, that there is not. There is only one market where NIT was issued, and NIT is only one person on our market. Kindly similar that, yes, that is on yellow, right? Similar, annexer one, please 12 million.
Have you denied that the market of Mr. Ali is not an existing market since last 40 years or 30 years or 10 years?
Subsequently, I could know that there is a market on that way.
so one more aspect
Once you bid for the market, you are supposed to know the situation.
Situation, yes, yes.
At your instance, and in a case of this nature, interference will not be possible, may not be possible, will not say will not. Because there is a vast difference in the case of 3779.
This one is another thing. There is a totally will not my commission, sir. There is getting another NIT was issued.
Because
by
the
by the authorities.
entire NIT was put to challenge. It's no question of NIT. You are a lessee, you say, suddenly find that there's another market going on. And you say, and you can't come against that, but that market is going on for last so many years. And you are the landowner.
Yes, my lord.
They are running on permanent basis.
This market is started on this year. The whole thing, distance, my lord,
This is from 80.
I'm
No, my lord.
there is long by 1980, Baliguri is nearby.
there is this
And in the
Yes,
Miller,
yeah, my
whole
lord.
Assam Miller will be market, private market will be constructed. Miller. Yeah, they haven't heard it, so we are constructing the market.
You say he is false, he's saying you are false.
I'm not sure they any document regarding the market at this.
Yes.
And the government will show me, I will not our review. Now at present I am lessee. I am holding the charge.
Government.
lordship may
And
kindly
government
take
is
for a
doing,
moment, my lord,
our-
the affidavit of position filed by the private respondent, my lord.
Yes, what is there?
Case 32, my lord.
Hmm.
This is a case filed by the private respondent, my lord. An order has been passed not to disturb the private respondent, my lord. The Patal end of the,
In their case,
yes, my lord,
They also got
yes.
are you parties here? The
No, railway purpose 30.
Panchayat, the government is there,
No,
private.
Government by land, but there was a police atrocity was coming, police closed the market, that is a.
And this aspect, my lord,
Page 35, your lordship.
page 34, last paragraph starts from,
35.
it was submitted, my lord, that another NIT was issued, my lord.
Page 35.
Taking note of the grievance expressed by the petitioner as this court while.
what is your name? Bagbor Cattle Market,
Yes, yes, yes.
at page 35, last paragraph.
Middle, yes.
Situated thus, I have no hesitation in holding that interference of the respondent number 8 in operation of the cattle market run by the petitioner. Petitioner means his client
Yes, my lord.
is unauthorized. I therefore dispose of the petition with a direction upon the respondent not to interfere in the operation of the Bagbor cattle market over the private land, patta land of the until and unless the same is found to be violating in any provisions of law. You show any law has been violated.
That was regarding police obstructed their market, my lord. In the last year, many lordship processed similar orders, some orders, my lord.
In view of
That-
this,
that
in
is the
view,
case, my
in
lord.
view of this, order passed by this court in a writ petition filed by your friend, our hands are absolutely tied. This will be the last nail in the coffin. We close
Your
this,
lordship,
My lord.
let it peacefully die
my lord, this will be
without further,
endeavor, my lord.
huh? No further arguments, no further altercation.
My
Let
lord.
it die peacefully. Third, Sri A. Rushid, Land Council for the petitioner. Also heard Sri as Dr. Land Standing Council, PNRD Department, whereas the respond number 8 and 9 are represented by Sri H. Ali, Learned Council. Full stop. Considering the subject matter in question and as agreed to by the parties, comma, this writ petition is taken up for disposal at the admission stage. Full stop. Pursuant to a tender process, comma, the petitioner was the successful bidder for the Torar, as each side was telling to, Torar Bhita, Jonapriya, Ancholik, Gorur Bazar, and was accordingly settled with the same for a period of 1 year, with effect from 1/9/2022. Full stop. The said market is a bi-weekly market having which is operative on every Wednesday and Sunday. Full stop. The grievance of the petitioner is that the respondent numbers 8 and 9 are operating another market, namely the Bagbor Bazaar, for mainly for cattle. Full stop. The further allegation is that the days of the said Bagbor Bazaar is also on Wednesday and Sunday, and the distance between the two markets is about 1.5 kilometers, is about 2 kilometers. And full stop. The petitioner's case is that because of the activities of the market of the respond numbers 8 and 9, comma, it is the petitioner is suffering loss and legal injury and a loss, and accordingly the present writ petition has been filed. Full stop. Has been filed with the following prayer. Full stop. We proceed. The Learned Council for the petitioner has submitted that while he is the lessee of the Taurar Bhita Jonapriya Ancholik Gorur Bazar, which is duly settled by the Gao Panchayat. Which Gao Panchayat? By the Mandia, not Mandia.
Mondia Anchalik Panchayat.
It's Ancholik Panchayat. By the
Gao Panchayat,
Mandia,
Bagbor Gao Panchayat.
by the under the Mandia Ancholik Panchayat, comma, the market of the respond numbers 8 and 9 is a private market. Full stop. He submits that the business of the private respondents is adversely affecting the business of the petitioner, which was duly settled with him by the appropriate authorities. He therefore submits that a direction be issued to change the days of operation of the market of the respondent number 8 and 9. Full stop, para. Par contra, comma, 3. S. Datta, learned standing council, PNRD department has submitted that the notice inviting tender did not stipulate any such clause, and the offer was made open under the existing conditions. He submits that the petitioner was fully aware of the existence of the market of the respondent numbers 8 and 9, and therefore he cannot have any legally enforceable right to seek the change of dates of a market, that too in a private land. Full stop. The Current Standing Council has also drawn the attention of this court to an order dated 22/7/2022 passed by this court in WPC 4440/440, 2022, which was instituted by the present private respondents against certain interference in running of the private market by them. Full stop. This court, while allowing the writ petition, has directed that there should not be any interference with the market of the respondent numbers 8 and 9, which was run over a private patta, with a private land, unless and until they are found to be violating any of the provisions of law. Full stop. Para. For ready reference, comma, the operative part of the judgment is extracted herein below. In support of his submission, comma, is a Hiri Rashid Alexa before as doctor. Sri Rashid has relied upon an order of this court dated 3/6/2011, passed in WPC 3779/2010, in which an NIT floated for settlement of a private market was set aside. Full stop. Full stop. However, a close perusal of the said order would show that the petitioners in that case are the present respondent numbers 8 and 9, and the challenge was against the NIT floated by the Panchayat authorities over for initiating a tender process for settlement of the market, which is on the private land of the petitioners in that case. Full stop. That's what Dr. Hall. That's what. 3. Ali, the learned counsel for respondent numbers 8 and 9, submits that no legal right, whatsoever of the petitioner has been infringed infringe, giving him any right to approach this court. Full stop. He submits that apart from the fact that there is an existing order of this court directing non-interference in running of the private market, the present petitioner is only a lessee whose term is going to be over very soon and who had submitted his bid knowing fully well about the existence of the market of the respond numbers 8 and 9, full stop. He further submits that the panchayat authorities are not aggrieved by existence of such markets, and the lessee as such cannot have any right to make such challenge. Full stop. Para. You are for anybody? Who? Anything? Sri, upor dekhiba, N. Goswami, upor level. Sri N. Goswami, United State Council, is present for the Deputy Commissioner. Borpeta? Last audible. After hearing the Senate Council for the parties, this court is of the opinion that the petitioner had participated in the tender process initiated by the NIT dated NIT. What is the date? 27/6/2022. By at a time when the market of the respond numbers 8 and 9 was existing, full stop. In fact, going by the version of the said respondent numbers 8 and 9, their market on the private land is existing for last about 40 years. Full stop. So when the bid was submitted by the respondent, by the petitioner for the solar market, it is expected that he was fully aware, and it is presumed that he was fully aware of the situation and thereafter had submitted his bid, full stop. Further, this court finds force in the contention made on behalf of the respondents that the panchayat authorities as such are not aggrieved by the operation of the market of the respondent numbers 8 and 9, full stop. This court is also of the opinion that in view of the order passed by this court on 22/7/2022 in WPC number 4440/2022, which was instituted by the on behalf of the present respondent numbers 8 and 9, there is hardly any scope to entertain or pass any orders in this writ petition. Full stop. After consideration of all the aforesaid facts and circumstances, this court is of the opinion that the petition lacks merits, and accordingly the same is dismissed. The order dated 3/6/2011 passed by this court in WPC 3779/2010 is not at all applicable in this case, and would rather come to the aid of the respondent numbers 8 and 9, as in that case, an NIT floated by the respondent, floated by the Panchayat authority for settling a market on the land of the petitioner was interfered with holding or interfered with by on the issue of lack of jurisdiction. Full stop. Absolutely. Petition status. Yes, next. Is it any forest department council? You seek time? Yes, RR Gogoi, date to require. List after the Bihu.
May I prefer fixed date, Lordship?
Huh?
Fixed date after Bihu.
Tell us, list on
On 25th,
28th.
28th, very well, Lordship.
History, list on interim order. Yes,
Oh, Lordship.
this is item number,
11 and 12.
you record, you okay, does record your name? Okay, does or RR Gogoi for 17. Interim order, you need attention. What is the interim order?
The interim order was passed on 8/2/2023, Lordship, signed that at page 4, Lordship.
Vacated over.
That has been subsequently vacated on a submission made by the respondent council that the award has been passed, Lordship. We have not received any copy of the award. Only thing is that we have received the compensation, but we are agreed by the assessment of compensation. And we have an alternative remedy to approach the arbitrator.
What is
Lordship.
the interim order that was passed and you are seeking to be renewed?
Lordship, that we may not be forcibly evicted from our land, Lordship. But
After
we-
receiving of compensation, can you say that?
We are agreed by the assessment of damage, compensation.
No,
Lordship.
that will be,
Till that amount is determined by the arbitrator till that. So some protection may be granted, Lordship.
that is not connected at all. Your,
Still that-
the sufficiency or adequacy of the compensation has got nothing to do with your displacement.
Because
That's a
under the
different
Act,
issue.
Lordship,
That's a different issue. We may direct them to expedite the process. But you cannot say that I have not received the entire compensation or full compensation which I think I should get. I'm not going to vacate.
but there is an alternative remedy, Lordship, as provided under the Act. So I may be allowed to approach the arbitrator, but if the amount is determined by the arbitrator,
Oh.
protection may be granted. Otherwise, we'll be rendered homeless, Lordship. And if my house is demolished, there will be nothing left for making assessment, Lordship.
The law with regard to acquisition is not like that. Acquisition is done compulsorily. Unless you find, unless you can,
We are bound to take it. up,
unless you
Lordship, I understand.
come up with it in the challenge that there has been a violation of the statute, there is no question, scope of any interference. Sympathy, other grounds are not relevant at all.
Ready to vacate the land.
No,
Lordship.
that's not,
Only
the
submission.
question of readiness is also not there. For the issue of adequacy of compensation, there is a mechanism in every act. If you go to 1894 Act, you can go for a reference. If you go to NHA Act, there is a similar provision, all acts. If
Lordship,
you may
I
be
may allowed
dissatisfied with
to-
the amount, you have a remedy.
Lordship, I may be allowed to this of this bill code, Lordship, with regard to, I am praying for a similar direction.
Yes, let us see.
Some protection I am seeking, Lordship.
Next 15 days. Only 15 days stay.
Lordship, there are 10 petitioners in my case, Lordship.
We will give you 20 days, 5 more days. This is not a stay order. We thought this was a stay order. This is only to
Some
facilitate you,
protection, Lordship, the.
only
interim
to
protection
facilitate you
Lordship.
to approach the alternative remedy. This is not a
Simple.
blanket stay.
Lordship, a simple direction, that is what.
See,
I'm
this is
seeking, Lordship.
pending since when? When did you file it?
It was filed on 27th of February 2023, Lordship.
The 15 days. Much more you have already got. put out an order from this court. What else do you need? Hmm?
Lordship, protection, Lordship.
The doctor has not even seen you. You have already got the relief. So you can go back home. Yes, what do you say?
If you want to look into the picture, my lord, except three, my lord.
Whose picture?
My lord, this is the
We
picture of
are
the.
not looking into
My
this
lord, my
picture.
lord, just was
We
saying
got
that,
some other pictures.
my lord, they have already, except three people, my lord, others people had already vacated the premises, my lord. Only three people, so they are also removing partially, my lord, and they are not fully removing. And already we wrote to the, my lord, deputy
They are
commissioner,
more aware of their rights.
my lord.
These three people are very aware of their rights.
Now, they have, my lord, alternative land. They have more than 20 bighas of land, my lord. They are not the landless people. They have already land. They have already constructed
But
the
Madam
land.
has said they are
after
very
their
poor. They are very poor.
My
They do
lord,
not have any house.
if your lordship look into the picture, they have
You only
already,
have 20 bighas.
they have already constructed a house, my lord, after the construction of that portion of the
That I
land,
do
my
not
lord.
know, Lord. That
They have already,
inspection I do not have.
RCC building, they have already constructed, but they are approaching this court, my lord, and taking
We have
the
pictures of RCC building also.
RCC building, my lord. They
How
have
do you know
already
it is their
constructed.
house? It may
And
be,
petitioner number 8,
it may be your house also.
petitioner number 8, they have already constructed the
Yes.
RCC building. Lordship, just look into it, the before eviction and after eviction, all the pictures. Only three people are not removing, my lord.
Before and after.
Before and after all these things, right? All the petitioners, only petitioner number 1, only three petitioners are not removing
This is before.
before, my lord.
So she is removed on her own.
On
self.
her own, my lord. There is nothing to be removed except, my lord, 3. 9, 10, and my lord, petition number 6.
Where is after?
Next page, my lord, first is the before and after. All the pages are there, like that.
Oh, next is the after.
Next,
Okay.
next is the after, my lord. First is the before, second is the after.
But one window you have removed, why?
Only just, my lord, PTS, she is only not removing, my lord. Others are has all been removing. They have only removed the grill and
This house will go now.
house will go. Then received a compensation more than 83 lakhs, my lord. They received a compensation amount of rupees 80 lakhs 25,450. And the land compensation amount received, my lord, 8 lakhs 24,643. But
Lordship,
that
then I
particular
received-
person's one.
Bornali Uzir.
Only with you, my lord. They have that, my lord, government employee, they have the flat own. All these things are there. They are not.
You're a
the
government
landless people.
Lordship, Lordship, but then I have the
Not
right to
only-
receive my fair
No,
compensation.
no, we are just
Yes, my,
asking
it is
whether-
not the way, my lord. Civil service officer, my lord.
we're not saying you're
So-
not entitled for your rights.
My house is getting demolished, Lordship. My homestead land is gone, Lordship.
We'll grant you some time only to approach the arbitrator. 15 days.
Lordship, there are 10 numbers of.
The others are already, my lord, also
15
recorded,
each.
my lord. Others are already
150.
vacating, my lord. Only 3 persons only.
150 days.
Not 150 days, Lordship. Can it be a month, Lordship?
It's like a question, if you take
Well,
3
it
minutes
is
to
a-
boil 1 egg, how much time will you take to boil 10 eggs?
Lordship, because the public
Will it be
interest and
30
private
minutes?
interest.
It's the same time.
Lordship.
Third, MS M. Devi, Senate Council for the applicant petitioner, who by means of this applicants petitioners, who by means of this IA has prayed for renewal of an interim order dated 8/2/2023, passed in the connected writ petition WPC 637/2023. Full stop. It is the case of the petitioner that a writ petition that the connected writ petition has been filed. No, it is the case of the applicants who are 10 in numbers, that the connected writ petition WPC 637/2023 has been filed against the action of the respondent authorities in this going ahead with the acquisition process of land for widening or what? For construction?
Widening of,
Construction of the widening. Is it Assam Mela?
no, Bharat Mala,
Bharat Mela.
National Highway, my lord.
For construction of the widening, which is a part of the scheme of Bharat Mela
NS 29.
in the National Highway
29.
29, full stop. The petitioners, the applicants' case is that they had their residences over their respective plots of land, and the amount paid to them is inadequate, and therefore without coming to a fair determination of the compensation, the petitioners should not be displaced from their respective land, nor any damage be caused to their residences. Full stop. Para. This court, by order dated 8/2/2023, was and had passed an interim order. Where is that page?
The page 24, Lordship, of my IA.
Interim order.
20.
Page?
Is 21st.
What is page 30 then?
The two orders. First one is.
That no coercive action be taken to evict the petitioners, to evict the applicants, within bracket petitioners, from the land under their possession. Full stop. The said, this court had also made an observation that the interim direction would be reconsidered on the next date after obtaining of instructions, which included the issue as to whether the award was actually passed. Full stop. On the next date, this court was informed that the award was indeed passed and the petition and the applicants had received the compensation. Full stop. On that basis, the interim order was vacated. Full stop. It is the case of the applicants that if they are made to, if they are displaced without determining a fair compensation, the legal injury would be caused to them. Full stop. Para. MS Devi, the learned counsel for the petitioner, fairly submits that it is that they are not, that it is not in dispute that the applicants have received amounts in the name of compensation, which, however, is wholly inadequate. Full stop. It is further submitted that though an alternative remedy is available, some protection may be granted till the compensation is fairly determined. Full stop. The learned counsel for the applicants has placed reliance upon an order dated 29/12/2021 passed by this court in WPC 7303/2021. Full stop. Para. On the other hand, Shri J. Chotia, Learned Standing Council, AAAC, submits that the
Except petition number 6, 9 and 10, others had already removed their.
submits that except for petitioner numbers applicant number 6, 9, and 10, the rest of the applicants have already
Remove their structure.
have already moved from their from the locations in question. And the location full stop. So far as the other applicants are concerned, a part of the
Partially removed.
structures, there have been partial removement, there has been partial removal of the structures standing there. Full stop. The standing council submits that the issue of sufficiency / adequacy of compensation cannot be related to the issue of displacement. Full stop.
And the
He
land has
submits
already been
that
vested with
he
the central
submits-
government under section 3D.
He submits that the remedy lies with the adequacy, he submits that the issue is only with the adequacy of the compensation, which would be determined by following the mechanism, public process prescribed in the statute itself. Full stop. It is otherwise submitted that a proceeding of acquisition of this nature cannot be challenged unless a party is able to demonstrate violation of the statute as the proceeding has been initiated wholly for the interest of public service. Full stop. Para. After hearing the parties and on perusal of the records, this court is of the view that since an alternative remedy in the form of approaching an arbitrator under the
Under
National
section
Highways
3,
Act
section
1956,
3G5, my lord.
under section 3G5 of the National Highways Act
Act
1956 is provided, is provided for
Proceed
determining
arbiter.
the issue of compensation, this court is not may not be the appropriate forum for adjudication of a dispute of this nature. Full stop. So far as the prayer for renewal of the interim order is concerned, the interim order was passed on the sole consideration that the award was not passed. And in fact, it is admitted by the parties that the award has been passed and the only grievance is with regard to the adequacy, public sufficiency of the award, for which the parties are required to invoke the provisions of section 3G within bracket 5 of the act in question. Full stop. However, following the order, this court has also noticed that in the order dated 29/12/2021 passed in WPC 7303/2021, which has been relied upon
At the motion stage.
by the
order was-
petitioner, the interim order, no interim order as such was passed, and it was only provided that till a period of 15 days comma, no coercive action, no demolition be taken, only to facilitate the petitioners in that case to approach the competent authority for land acquisition. Be that as it may, comma, by following the, be that as it may, comma, in the interest of justice, comma, while the prayers of the applicant cannot be exceeded to, comma, it is provided that the applicants are at liberty to approach the arbitrator under the aforesaid Act of 1956 within a period of 15 days from today. And till such, and till,
But
the-
fix a date, my lord, we may allow me after Bihu, my lord, till 19 or 20.
let's say 15 days to be, 15 days is, which should, the outer limit of which is fixed on,
20 or 20 or 25,
Madam?
my lord.
you tell,
Well, 5 is the 15 days. How many days you will require? 15 days. 5 into 15, 20,
till 21st,
21st, my lord.
till 21st. And in between, Bihu will be there.
Yeah,
Yes,
Bihu, all
Lordship,
of
that
14,
is
15,
fine.
16, Bihu is there. So after Bihu, my lord, till 20.
Why 24th is a holiday?
24th is the, my lord, holiday.
Because of
Eid.
Eid, Lordship.
Let it be till 28th,
28.
wait.
My lord, then
22nd, I think.
But 20, my lord, summer will come, my lord.
Oh, yeah.
Road cannot be constructed there.
No, you are
after the
correct,
rain
you
will
are
come.
correct. Till 21st,
21st.
till 21st of April 2023. Bolo, Master. Bolo. At liberty to approach arbitrator. Act 2A capital. Act 956. Within a period,
21.
within 21/4/2023. So, to facilitate the petitioners, the applicants to make such approach, comma, no course of action be taken till
21st.
21st of April 2023 against the petitioners. The IS stands disposed of.
Obliged.
Anything left to be decided in the writ petition?
But another point is there, my lord. By virtue of this order, my lord, they will approach the arbitrator and arbitrator asks for interim order from the arbitrator not to evict. That is the difficult that is going on there, my lord. So our concern is only that, my lord. And
But we have not said, given them
but,
in
no,
liberty.
but your lordship has passed the order that they will approach the arbitrator. They will, in other cases, probably in Bipul Sekha case also, my lord, they took that plea that High Court has already passed an order. As such, as you have not decided till that we should not be evicted. That is the point, my lord, left out, my lord. That will be our difficulty. In this case also, same thing will happen. Otherwise, public interest, my lord, will, my lord, suffer, my lord.
But we
that
have
is
not granted them
But,
any liberty to
your
pay.
lordship, that can be interpreted like that way, my lord. That is the difficulty, my lord. In other cases also.
Arbitrator has a,
Arbitrator has no power for, but has the
Interim order.
power, interim, they can pass an interim or not to evict till the assessment. And it will going on 1 year, 2 years like that way, my lord. All these things are there. Your lordship, you will consider that aspect also, my lord.
no, we have already indicated that,
Till, my
that you
lord,
cannot-
lordship,
no, no.
use the word till, my lord, approach
21st.
the competent authority.
no, till 21st. We have said till 21st. The interim order is till 21st.
My lord.
Nothing
But
more.
otherwise, my lord, if your lordship
No,
pass the,
in the order, we have indicated that acquisition proceedings cannot be stayed.
my lord. But despite that, my lord, that is going on there in the arbitrator before the arbitrator. So that is
They
a
have to
difficult
show
point
that
out.
there is some statutory violation.
My lord, but arbitrator under the Arbitration Act, my lord, arbitrator can also pass the interim order. So arbitrator
You
pass the
follow the
order,
96 Act.
my lord, and in 56 Act, my lord.
No,
Yes,
arbitrator.
1996 is applicable, my lord. Here,
Procedure of 96.
so it is there, my lord.
Section
So the
9.
arbitrator taking that plea,
Section 9 or what?
my lord, section, my lord, it is there that
9, no, not
No,
9, 17.
arbitration and subject to Provision Act, this arbitration and conciliation 1996 shall apply to every arbitration under this act.
Section 9 or 17? 17, I think. 9 is sports power.
My lord,
17, I think.
section 3G.
No, Arbitration Act.
Arbitration and 96, my lord.
Which section? I think
The
section.
section, whole act is applicable.
No, for interim order. 17, I think.
Or 7.
No, arbitration.
Introduction? Yes, ma'am. Arbitration again.
The commissioner.
And in this case, arbitration is the arbiter is the commissioner, my lord. 4 years, sir. Last 2 years, our cases are pending there.
2 years.
2 years, last year, before the arbitrator, my lord.
You come up to the court.
That is the landed procedure, my lord, like that, my lord. They can approach the arbitrator on their own, my lord, but the
But,
lordship may grant
The
the time.
current trend.
In that case, my lord, in a motion stage, that order was passed, my lord. And
But the
without stating the,
current trend is not to
the trend is that is there, my lord.
minimum interference in judicial proceedings.
In the Vipul Saikia's case of the part of the house was, my lord, acquired, my lord. So the construction of the highway in Karbi Alang, my lord, almost 85% road has been completed in comparison to the, my lord, Upper Assam or like that way. And
Yes,
but
yes.
about all the cases, my lord, 30 cases are pending. If all the cases are taken up, my lord, it can be decided.
You tell us,
I have at least, my lord, 30 cases are there. All the cases are like that way, my lord. It is pending before.
you
this
make a
court.
mention before the
My lord,
appropriate
after
court.
my lord, Bihu, my lord, I'll mention Ibra, all the cases, my lord, if you
Yes,
list
yes.
together, my lord, it can be disposed of, my lord.
Yes, next.
Well, item 15, it was fixed today for disposal anyway. But I want.
My presence kindly recorded for respect for National Highway.
We are seeing for Standing Council for National Highways. And Goswami, State Council. For
NHIDC.
NHIDC.
Item number
Well, regarding item number 15, it relates to the settlement of Barghat. But last occasion, my lord, your lordship taken up the matter, my lord. My friend Hawk was there. So, my lord, in spite of the fact that there was a stay order, they are not settling the matter. And we have filed our reply also. The lordship gave an objection, the endeavor would be taken up, but because of the paucity of time, it is not possible to reply.
Where is
And-
Mr. Hawk?
Lordship,
Hawk-
I am for the petitioner, Lordship,
Yes.
and I could not file the reply, Lordship, the in opposition file with response number 9, Lordship. Lordship, my prayer is maybe taken after vacation. In the meantime, I can file the reply, Lord.
He's saying there's some violation of orders.
My lord, I am appearing for the IWT.
Yes.
My lord. My lord, we have also received instructions. We'll also file our affidavit.
And file your affidavit.
My lord.
But they are not settling us, my lord. We are being highest bidder.
Is there any interim direction?
No, there was no order.
My lord, we'll interim is not there. We'll file our affidavit.
It's up to you. We cannot force you.
So we pray for a fixed date, may be fixed. kind of.
Yes, both Sri and Hawk Learned Counsel for the petitioner. Sri and Hawk Learned Counsel for the petitioner submits that the private respondent number 9 has filed an affidavit in opposition, to which you'd like to respond, full stop. At the same time, Sri R.D. Goswami, Learned Counsel, appearing on instruction of MSMD Bora for the transport, for the IWT, submits that the department's affidavit is also required to be filed, full stop. List on,
After vacation.
tell us the date.
After vacation,
Tell us the date.
the only date may be fixed.
List on 28/8, 28/4/2023
Of right, diploma.
for exchange of litigants.
Lordship, item number 18 is fixed for today for a hearing.
Yes.
So Lordship, it will be taken on 11th, Lordship.
Who is on the other side?
Mr.
You are there.
Yes, I can,
You said some compensation matter.
Lordship.
You said compensation matter.
No, Lordship, I have executed a construction of the four laning from Jorhat to Jhanji. Amount is, I am entitled to get 11 crores. In the meantime, I have executed the work by taking loan from the bank and my account become NPA.
Yes, why haven't you paid?
They are not entitled to it. There is no contract, my lord, between the, my lord, NHIDCL and the.
No, that is not correct, Lord. There is a contract.
He is the subcontractor.
He had a contract
which-
with the original contractor. All
Was
the-
it allowed? Was subcontractor part of the lease deed?
Hello?
Your primary contract
Lordship.
agreement with the main contractor,
Lordship.
did it to have any clause of allowing subcontract?
Yes.
Yes,
Lord.
with the approval.
Clause is there, very clear.
If the.
And is there any communication by your the primary contractor that it has been done by him?
Yes, yes, it was approved.
That is not
He has
disputed.
been approved.
Then what is the
He
problem?
was approved, and in fact, in the affidavit, we have said that he has executed the work.
Then
But his claim is for my lord, from the principal contractor. Not, and my lord, principal contractor had dues to be paid to the NHIDCL, which the amount has been adjusted with them. That is the.
Lordship, after adjustment
Otherwise,
of the
payment,
penalty,
etc.,
I
we
am,
have-
as per their document, after adjustment of the penalty, Lordship, I am entitled to get 11 crores. That is admitted fact, Lordship. My account become,
oh, the primary contractor has dues with you,
Yes,
and whatever he is now claiming
he's up.
has
he's
been
up-
adjusted. Otherwise, his claim you are not denying per se, but only because
He walked, his whole claim would be my lord, from the principal contractor. That's the.
Lordship,
is the principal contractor a party here?
yes.
as per
Who is
law.
appearing?
No,
No one is aware.
notices were served, they did.
Who is the
But
principal contractor?
The Swedish company, Lordship,
Corson
CCCV and Corson
Kabam.
Carbium Construction, Lordship, Swedish company. After taking the mobilization amount, he did not do anything, Lordship. And thereafter, as per the subcontract approval, Lordship, I
But what,
executed.
tell us what relief will we be able to give you?
No, I am entitled to get even under section 70 of the Contract Act,
No,
Lordship.
But they have already adjusted with the principal
No,
contractor.
no, after adjustment of the amount of the principal contractor, Lordship, like damages and penalty, there is a payable amount is 11 crores. That is admitted amount.
What is this? What is this? What about this?
Yes, sir, Lordship can see
Huh?
the
This principal contractor had executed another works. But there, my lord, his due was something about 17 crores and not, 19 crores and not. So he's, my lord, from this contract, he is to get 11 crores. So these 11 crores has been adjusted from that.
So other work.
Lordship.
to which I am not
NHI
related,
between
Lordship.
this.
That contract, other contract is from Jhansi to Dimau. I work from Jorhat to Jhansi only, Lordship. How they can deduct?
Two package was given to the principal contractor.
One was,
No, we don't have any, my lord, we don't have any PVT of contract with them. my lord. We just allowed this
No, no.
subcontract.
Lordship,
They
in
are
the
not a
contract
assignee
agreement,
as such.
there is clearly written that the subcontract will be treated as a main contractor, Lordship, because the main contractor has assigned the work to me.
Mr. Roy, don't you think that essentially your grievances against the Swedish company?
Yes.
No, that company is declared insolvent by the Swedish government, Lordship. All things are on the record, Lordship. And Lordship, I work to only from Jorhat to Jhansi.
Now, this money involved is public money. We cannot just force them to part with public money.
Lordship, it is the authorized engineer of the NHIDCL, Lordship, to recommend the payment. The authorized engineer recommended that this work done by the present petitioner and his amount should be released. In spite of that, they have not released.
We
And now, Lordship,
released-
I have
we
executed
released
the
the
work
amount
by
to the
taking
principal
loan,
contractor.
Lordship. And my account become NPA and they are going to take my residence, Lordship, bank under the Surface Act,
Okay, we'll have a date possible.
11th.
11th, just above the, this will take time, it'll be after vacation.
But 11, 12, we don't have much of an issue.
Then 20th, Lordship.
No, we don't have too much of a problem. Other issues are not there. Work, of course, case basis may be there. It's always already there. 11 we can have if you are willing, or otherwise on 27th,
27.
the Thursday,
It can, on 20th, Lordship,
20.
Thursday, yes, it is Thursday.
20, is it okay?
27 would be,
Lordship, under the Surface Act, my residential
Let
accommodation.
us agree upon a date.
not only a matter of a week, because some matters are fixed on 20th, therefore, my lord, I'm requesting for 20.
For paucity of time did not allow the matter to be taken up today. SP Royal Learned Counsel for the petitioner has expressed urgency in the matter. List as agreed to by the parties. Oh, PJ Saikya, Learned Senior Counsel is present for the NHIDCL.
NHIDCL.
As agreed to by the parties, list on
He's insisting on 20th, my lord. Let it be on 20th, we'll.
20.
Otherwise, my lord, I'll.
24.
Obliged. Twentieth, no, Lordship, 20.
20. 24. This Sunday.
I pray for a date in respect of item number 13 and 14. On 27th,
Oh, Sultan,
I'm suffering, my lord, this.
you are protected by an interim order.
So that was in respect of the other, my lord, they are altogether 6
You are
days.
suffering because of that. We vacated.
No, because of this, my lord, my fate is still hinging, my lord, because they said those allotment will be subject to the, my lord.
You want all the relief in one day, not
No,
an
that's-
installment.
I was over, my lord. Now only for one, my lord. Not for all.
It is not enough for you.
So all on, my lord. this-
Oliver asked for more.
Lord, I'm just looking for my dues, my lord. All the new vehicles bought on, my lord, my lord, bank finance. Dues amount more than 60.
Your tanker does not have a tank.
My lord, that is not the case there. The whole-
Photograph, we have seen the photographs.
My lord, I have said, my lord, in the petition also, I have said the videograph is there. I have given it to the transport department. You see how the police personnel and the others have, my lord, demounted the tank and
Yes,
taken.
there's somebody else in the IOC is there, I think.
My lord.
No, my lord, here IOCL will not be affected because it is between the transport department and.
Transport Department,
The
madam.
dispute is both the petition filed by the petition, in that case, it have influx to us because we have again renewed his suspension order for another 3 months or till the final disposal of this honorable court. Particularly.
This was, my lord, pointed out on the other day, and since it is already sub judice, so any order that passed.
No, there is no
subsequently,
direction from this honorable
We
court.
have till now, we have not
The
received any order.
earlier suspension order has been silenced by this petitioner,
Yes.
and this was
There was no
expired on
stay. There was no
26.
stay.
There is no stay.
And you have renewed the suspension. Have you served upon him?
No,
Yes,
at least I have, my lord, so far as my client is,
Yes,
he has
yes.
not received.
Take instructions.
No, not received.
yes.
Yes.
And then these are subsequent, my lord, I can bring it
Yes,
on
sir.
record by of an additional.
date?
Sultan Ahmed, yes, my lord.
Madam,
It's
madam.
dated 23rd of March.
Have you sent it to the petitioner
I
also?
the petition, name of the petition is.
My lord,
below,
Lordship will record
copy
this
two.
statement also, my lord.
Even Salman Khan was Sultan.
No, Lordship, Sultan. Lordship.
No,
My lord, her statement may kindly be
Salman Khan was
recorded.
not
This served.
Sultan.
This serve only because the
My
copy
lord, my
has
lord,
been
no, no, my
served
lord, my
to
lord, these are deliberate.
You don't know what is
time and
Sultan.
again, my lord.
Are you aware what is Sultan?
Sultan is the lordship. Oh, yes, yes.
Oh,
maybe,
yes.
my lord.
Is it? We did not know. Yes, what is your address? What is your name?
Sultan
Sultan.
Ahmed,
Can continue. This is a recent order,
my lord.
23rd March.
Well, this her statement may also be recorded. My lord, I'll show, my lord, in this particular case, two aspects of the matter, my lord, how the, my lord, very, my lord, the courts are
Out
taking.
Sri PJ Saikya, Learned Senior Counsel for the petition. I've also heard MSMD Board, Learned Standing Council, Transport Department, who has placed on record, has placed before this court an order dated 23rd March 2023, issued by the
Ensures the Assistant Commissioner of Transport.
DTO
Kamrup.
Kamrup Metro, whereby the temporary suspension of the vehicle bearing registration number AS01N and for Nagaon, NC and 8864 is further extended by another 3 months with effect from 26 March 2023 till full stop. The the senior counsel for the petitioner, Sri Saikya, however, submits that he does not have any information or instruction in that regard.
Well, I have definite instruction not received.
Hmm?
Till morning, he did not receive. That is my definite instruction.
Sri Saikya and senior counsel, however, submits that as per instructions received, no such order has been received by his client.
Person, kindly have a look, his name reflected in copy two, Sultan Ahmed. If the Sultan Ahmed, that person.
Kundil Nagar, Vasistha Chariali. Is it this your address? Maybe doesn't matter, is there? Okay, list on? Or no?
On 27th.
As agreed to by the parties, list on 27 April 2023 to enable the Senate Senior Counsel for the petitioner to obtain instruction.
My lord will fix for hearing only, my lord.
No, not hearing.
Because
Admission.
admission, my lord,
For
for admission, my lord, not for instruction. Let it be for admission.
No, if for this for admission to enable. no? We retain a copy of this. Do you have an extra copy?
Yes, Lordship,
There are two copies of same.
yes, Lord. One is for this honorable court.
Yes, one ownership. This has been stapled.
Fix for admission.
This is
Lordship, fix the matter on 27, my lord.
27.
I'm obliged.